There is no mic. You go near the mic.
My lord, we have engaged senior counsel, my lord. Narayan.
You are Narayan.
No, senior counsel we are engaged.
You are becoming senior counsel.
We have engaged senior counsel, my matter, my lord. Serial number 10, my lord.
What do you want?
We need time.
10.
Please.
3,000 days delay.
Please, my lord.
So when shall we keep? After 3,000 days? When do you want, Mr. Counsel?
Next week, my lord.
Next week is not possible. 19th of at the request of learned counsel for the complainant. No, appellant. 19th July. Yes, madam. Yes, Mr.
Double matter, my lord. It was no, my lord. I'm more for postings. Double matter was dismissed for non-prosecution, my lord. I filed an application for recall.
When it is filed?
Let's have filed an application on 11/7.
11th of? That you are not aware.
I'm filing an application for recalling the order dated 11/7/2020. I filed an application for recalling the order dated 11/7/2022.
When you have filed, unless you tell that we will not file. Yes.
Lord, I'm moving a memo for posting, my lord, with regard to a CC matter, contempt matter, my lord. I'm for the wife, my lord. My lord, the husband has agreed to pay 15 lakhs at the time of as a final settlement before the family court and the mediation agreement.
Earlier it was listed.
My lord,
This is fresh or to be listed again?
my lord, it's a fresh matter, my lord.
After 2 weeks.
My lord, Monday, my lord, Tuesday.
Monday, not
Tuesday, my lord.
My lord,
after 2 weeks.
my lord, old matter, my lord. We're seeking the interest payable on the gratuity, my lord. Kindly list it on Monday, my lord. We're seeking the interest payable on the gratuity, my lord. Kindly list it on Monday, my lord.
Monday.
Okay.
All right. 1st July.
My lord, kindly, my lord.
Serial number 29, your lordship, it's a PIL. Party person is not able to make it to Bangalore today. Personal inconvenience. So he sought for about 4 weeks' time. First week of July, I've already informed
The request made on behalf of learned party in person. Dr. Subramanian Swami, on the ground of this personal inconvenience, stand out to which date?
anytime after 4 weeks, first week of July, that's.
Tell the date. 10th July.
Much of it.
10th July, from as requested.
Lordship, kindly, my lord, serial number 8, my lord, arguing counsel had to undertake a travel. Arguing counsel had to undertake a travel on an urgent basis, my lord, request for a short accommodation in this matter. Serial number 8, please.
8. Why?
Please, my lord.
Why do you want time?
My lord, arguing counsel had to undertake a travel to Delhi on an urgent basis, my lord.
Who?
Mr. S.R. Kamlacharan, my lord.
Pradeep Savar.
My lord, he is also one of the. Mr. S.R. Kamlacharan is also one of the appellants. In the sense, he has also filed a vakal.
All right. When?
My lord, any date next week after.
2nd July.
Please.
Send over to 2nd July as requested on behalf of the appellant.
Obliged. Highly obliged.
Serial number 19, my lord.
19.
19. 19. 19, my lord.
90 or 19?
19.
What is?
Kindly 1 week time may be granted, my lord. Arguing counsel as personal inconvenience, my lord. Arguing counsel as a personal inconvenience. Kindly 1 week time may be granted.
Personal inconvenience. What is that? Who is arguing counsel?
Ganapati Bhatt. Ganapati Bhatt.
Oh, you are speaking very slow. Tell louder. Who is arguing counsel?
Ganapati Bhatt. my lord.
Ah. So, after this
1 week.
year or next year?
1 week. my lord.
In 24 or 25?
After 1 week. my lord.
January 2025?
No, my lord. After 1 week. my lord.
After 1 week. 11th July. As requested by learned on behalf of learned advocate. A petitioner stating that learned advocate has personal inconvenience, stand over 11th July.
My lord, serial number 27, I'm appearing for the respondent number 1 in this one. The respondent number 1 has demised recently, my lords. The legal heirs need to be brought on record. There is a daughter who's surviving who has to be brought on record.
27.
27, my lords. There was a Supreme Court case pending.
In
in
order
this
to
regard.
enable learned, in order to enable the complainant to bring on record the legal heirs, as requested, stand over to when? Till
Any date in the next 2 weeks, my lords. End of this month. only.
5th of July. 5th July. Yes, anything?
Much appreciated.
We are moving for memo for posting contempt case. On third, it was listed, my lord. Due to my father-in-law was dead and not able to appear. Third, it was listed, the contempt case was listed on third, my lord, 3rd of June. My father-in-law was dead, I could not able to appear before this court. It was posted to 9/7. I requested to post to next week, my lord, because the government has not complained for the past 4 months.
Which matter?
Contempt 426/2004, CC,
Which serial number?
no, not serial. I'm moving the memo for posting.
Last year it was posted.
My lord,
When it was posted?
3/6, my lord.
This 6 has gone. Today is which? Today 5/6.
No, my lord, on 3rd/6, my father-in-law was expired. I was not able to attend.
6 has gone.
Lord,
3/6, 3rd of June has gone.
has gone, my lord. Yes, I'm moving the memo for posting for.
Everything is gone, is gone. Yes. You file whatever you want to file to prepone. There is this, you can't be preponed like that. Once date is given. Yes.
So contempt matters, seal number 1. Prabhu Godapalli. The accused partition decree obtained is not challenged in RFA, wherein the initially the drawing of final decree was stayed. Even then, the accused tried to interfere in the schedule item property.
Interim order. Are you withdrawing or we are dispose of? It is an interim order.
Yes, my lord. Interim
We are
order.
not going to.
But so willfully disobeyed, my lords. I have produced the photographs.
We are not exercising our contempt jurisdiction in respect of interim order.
But
It is
there is-
loud and clear by now to everybody. Still you go on filing petitions, you are welcome.
May I request, my lords?
Wait, only dismissal.
My lords, may I request at least notice, my lords, because
Admittedly, the order brought under the contempt jurisdiction is an interim order. Full stop. Since the order, by very nature of the order, which is interim, no rights of the parties are crystallized finally. Full stop. The subject matter dispute is pending at large before the court concerned in the parent proceedings. Full stop. In that view, leaving the complainant to approach the same court to work out his rights and remedies. This contempt application is not entertained and disposed of accordingly.
seal number 2. So Baira Reddy.
My lord, land was granted in the year 1978.
This is an order of 2015.
No, my lord.
Hmm?
Order is on 16 November 2023, my lord.
Where is that?
Annexure D, my lord.
Representation is considered.
Consider.
It's considered.
You go.
It's in Kannada.
My lord, as per annexure
The land was granted in the year 1978, my lord. 1979, my lord. It is for, the Sagwal sheet was not issued, though the grant was made.
The land comes within 25 kilometers.
Whatever decided.
Lords, the land comes within 25 kilometers of BBMP limits. Lords, such lands cannot be granted. The law is clear, my lords, and the circulars have been
So
issued.
grant of land or mutation entry?
It is already granted in the year
Granted
on
land. they ask.
17/11/1979. The writ appeal number 4142 of 2013 is also allowed.
Following what the directions, it is complied with.
My lord,
Issued.
my lord, in the year 1979, there was no restriction bar as per this 25 kilometers jurisdiction, my lord.
So it is
It
complied.
is already granted, my lord.
Challenge it if you are not satisfied.
No, my lord, kindly,
Following what the directions.
kindly, my lord,
Ordered it.
Annexure B, my lord. Annexure B, my lord. Kindly Annexure B, my lord. The Tahsildar,
I have to speak louder than you, which I am not able to.
no, I was using the mic, so I'm sorry, my lord. Kindly
So please
Annexure,
permit to complete a one sentence, then you argue.
yes, man. My lord, the land was granted in 19.
Please wait. Following what the directions in order dated 16th November 2023. Of Lorna single judge which are sought to be complied with in the present contempt application. In page 32, paragraph 3 to be quoted. Yes,
My lord,
yes.
Annexure A, my lord. The land was granted in the year,
We are concerned with the directions.
yes,
paragraph.
directions was for getting the prior permission to issue Sagwal sheet. The Tahsildar writes a letter to the deputy
Commission
commissioner.
was to decide the representation in accordance with law.
Yes, my lord. May I read the,
It is now
may I read
decided.
the order of this honorable court, my lord?
Decided now.
May I read it? In this petition, petitioners are seeking direction to respond number 2 and 4
Yes.
to issue Sagwal sheet inter alia register the name of petitioner in the mutation register in terms of the order dated 33/2015, Annexure Q passed by this honorable court in WA number, writ appeal number 4142 of 2013. And pursuant to the order dated 4/2/2017 passed by the respondent number 2, that is the Tahsildar, my lord. Having heard the land council appearing for the parties on the careful examination of the amendments made in the writ petition, so also the finding recorded by the respondent number 2 at Annexure U dated 4/2/2017 and the letter dated 7/2/2017 addressed by the second respondent herewith to the fourth respondent herein. The fourth respondent is the deputy commissioner, my lord. I am of the view that grievance of the petitioner is with regard to entering the name of the petitioners in the mutation register, and in this connection, the only authority to take decision in the matter is respondent number 4. Accordingly, petitioners are directed to make a representation to the respondent number 4 herein within 2 weeks from the date of receipt of certified copy of this order. If such an application is made, respondent number 4 is directed to consider the same in terms of the observations made herein above, pass orders in accordance with law within 8 weeks from the date of receipt of such application. My lord, at Annexure.
So that according to you, it is not in accordance with the observations made.
Yes, my lord.
Then it is a part of merit, which you have to establish in the
May I
independent.
submit only 2 points? The writ appeal filed by the complainants has been allowed in the year on 30 March 2015 by the decision bench of this honorable court, my lord. Accordingly, the Tahsildar registered a case and he said all the grants are available, land is granted and all the records are available, and it's for issuance of Sagwal sheet, I need a permission from the government. So he writes a letter to the deputy commissioner seeking the permission on 7/2/2017, which was not considered till today. Then I filed a petition seeking directions to the Tahsildar and revenue and other revenue authorities for issuance of the Sagwal sheet, and order was passed, my lord. And it is for issuance of only Sagwal sheet, my lord. It is not for the grant of the land. The land is already granted. All the records are available as per the revenue authorities, my lord.
That is all. Thus, as per the above observations, the representation was required to be decided by the competent authority. Yes, respond number 4. The Deputy Commissioner, Bangalore Urban District. And the proceedings came up for consideration today. Came up for consideration today. Learned additional government advocate is Pramodini
Kishan.
produced, stated that the decision in compliance of the directions as above has already been taken. To stop in this regard, she produced copy of the endorsement of the order dated 6/3/2024. Full stop. It reflects a decision having been taken. Full stop. In the aforesaid view, paragraph, in the aforesaid view, it could be well said that the directions are complied with. Full stop. Although learned advocate for the complainant, so and so hard that the decision was required to be taken in accordance with the observations made in the order, and that such observations are not observed, such a part is not observed, the same, such submission travels into the realm of merit of the order. Full stop. Since there is a compliance of the direction by taking a decision, this contempt application is required to be closed. However, it is observed that if the complainant has any grievance about the merits of the decision, it is always open to the complainant to institute independent proceedings to challenge the same in accordance with law and on its own merits, in respect of which, however, this court does not express any opinion on merits. The present contempt proceedings accordingly does not survive and are disposed. The aforesaid copy of the aforesaid decision dated 6/3/24 shall remain on record, which is a copy of which is also given on a date of the complainant. Yes, next.
Number 3, Mr. Vasant Madhav.
Matter is again an interim order, but the fact is a decree of drivers was granted. That was challenged before this honorable court and the decree was stayed. Lord, the wife entered appearance before this honorable court. In spite of such appearance, my lord, subsequently she has married. Therefore, I am before your lordships that she has committed contempt.
Will permit you to go to the same court, having realized and accepted that the order brought under the contempt jurisdiction is an interim order from a learned advocate for the complainant, so and so. Seeks permission to withdraw the contempt application. Also, permission is granted. The complainant may approach the same court to work out his rights and remedies. This court, however, does not express any opinion on merits. Contempt petition is disposed of accordingly. Yes.
Number 4, Mr. B.C. Venkatesh.
For complainant. My lord, there is a direction given by Lord the single judge, my lord, to take appropriate action.
What is the direction?
Lord, page number 13, my lord, in page number 13. The writ petition is accordingly disposed of while directing the respondent assistant executive engineer to proceed in accordance with law against the respondent number 4 and take proceedings to its logical conclusion.
Or learned advocate so and so, the applicant, the complainant seeks to comply with the following directions issued by a single judge, extracting from the judgment, which is the operative part. In paragraph 4, page 13, this is red flag. Full stop. On bare perusal of the aforesaid direction, it is evident that no time limit is prescribed for taking out the proceedings and taking it to its logical conclusion. Full stop. When time limit is not prescribed by the court, it is difficult to come to conclusion. It is not possible to come to conclusion that at this stage, any of the respondents have committed any willful contempt of the direction. However, since the directions are passed by the court, they should not go uncomplied with. Full stop. Accordingly, it is provided that the direction in paragraph 4 of the order of Lorna Single Jet dated so and so, dated 24 July 23, shall be completed within a period of 3 months from today and 3 months from today, full stop. The present contempt petition is not entertained subject to above observation.
Much.
Number 5, to Satyananda BS.
Not for the.
Notice
complaint.
returnable on 19th of July.
Please. Number 6, to Naveen Chandravi.
Petitioner, my lords. My lords, this is an order which is at page 42, my lords, of this honorable court, and the operative portion is at page 56, wherein the applications of the petitioners for the post of primary school teachers, special teachers, was to be done within 3 months, and their qualifications were accepted.
Notice, Lord Leonard, Advocate, so notice.
Wait.
3rd July.
Writ appeal matters, so number 7, the Maitri Krishnan.
For the appellant, my lord. My lord, the appellants herein were the petitioners before the learned single judge. The petition was dismissed, my lord, and it was pertaining to a refund of the 15% of school fees that were charged during 2020-21 for unutilized facilities during the COVID-19 pandemic, my lord. As the schools were largely closed during the pandemic and all the classes were being held online, a 15% reduction was granted.
You are there.
But I appear for the.
We'll issue notice, assist on the next. Notice returnable on, because delay is also there. Notice returnable on 18th July.
Grateful, my lord.
Lord, I appear for respondents 1 to 4.
Learned additional government advocate, Ms. Nilofer Akbar. Accept notice on behalf of this number 1 to 4.
8 urgent, number 9, Mr. Madhukar M. Deshpande.
We have 65 days. I was the first respondent was having issue with the 2 advanced licenses, my lord, for the import of certain imports to be incorporated in the product to be manufactured, which is ultimately
returnable on 18th July.
So 10 urgent, number 11, Mr. Sanjeev BL. Number 11, Mr. Sanjeev BL.
Yes.
Pass over.
Yes.
Pass over.
Pass over.
This is number 12, HL Pradeep Kumar.
Request for pass over. Pass over. Pass over.
Compensation is directed to be paid, my lord, to respondents who are not the owners of the property. Admittedly, they were an unauthorized occupation of the government land. And not their application for regularization had been.
That has been rejected.
Yes, my lord.
Lord, grant if any has to be made, my Lord, before, my Lord, the acquisition notifications, my Lord, were issued. Lord, here is the case, my Lord, the grant, my Lord, has not been considered. After issuance of, my Lord, the preliminary and final notification in the year 2007 and 8, my Lord, the, my Lord, proceedings were taken place, my Lord, in the year 2016. After, my Lord, 10 years of, my Lord, issuance of, my Lord, the preliminary and final notification.
Arguing then
Lord, pass over, my Lord, the AG,
whoever.
AG, my Lord, Advocate General.
Number 13.
But I beg to appear on
Appearing
behalf
for
of the
Cavator
appellant
Lordship.
in this matter. I'm appearing for Cavator. May I seek 2 weeks' time to file application. No, my lord.
Not to be given.
My lord, it's a matter, my lord, the learned single judge posted on 14th for further hearing. And my lord, they're precipitating the matter also before learned single. That's the reason there is an urgency. In fact, they filed a Cavator.
Your
I
friend
served-
said there's no time to listen. Therefore, we are not giving. Yes.
If stay, my lord.
We are not giving. You are not giving. Who else will give?
I'm ready, my lord.
Proceed.
My lord, the appellant is a nationalized bank. And my lord, I am agreed by the order dated, my lord, 7/2/2024 at page number 32. The background of the matter is this. I'm a nationalized bank and my lord, the respondent number 1, my lord, availed a loan in the year of 2015. And my lord, created a mortgage in my favor. Subsequently, my lord, in the year of 2019, 5 years before, that account became an NPA. My lord, I initiated action under SURFACE Act and I issued 13.2 and 13.4. It is duly served upon the, my lord, borrower, respondent number 1. And later, my lord, he's not repaid any money. Therefore, my lord, I pursued further and I issued a sale notice under Rule 8.6 of the Surface Secured Interest Rules. My lord, I issued a sale notice on 19/12/2023 at page number 253.
So what will do before learn a single judge?
My lord, in fact, my lord, what had happened? They're assailed before the DRT. My lord, I'll just point out. They challenge, my lord, in fact, this very same securitization measures which I initiated, they challenged before the DRT under section 17. That's a competent court. My lord, all the, my lord, that they has to go before DRT. My lord, DRT after, my lord, prima facie case, my lord, he heard, my lord, they're not passing interim order.
Why should you want at this stage to intervene?
No, my lord, I just,
It is pending before learn a single judge.
No, my lord,
This status quo is granted only the till the next date of hearing.
my lord,
It is purely an interim order. Therefore, we are not going to
No,
entertain.
I'll just make it one submission. When, my lord, when SA is pending before the DRT, DRT refused to grant an interim order, my lord, after seeing the conduct of the respondent. My lord, kindly come to, my lord, section 17 of the Securitization Act.
Cannot going into any.
No, section 18, I'll just point out only 2 aspects. Section 18 of the, my lord, DRT is not passed an interim order. Section 70, I'm so sorry.
Debt recovery tribunal act.
Howdo? My lord, section 17 says, any person aggrieved by any measures referred to in subsection 4 of section 13 taken by the secured creditor or his authorized officer under this chapter, that to the debt recovery tribunal having jurisdiction in this matter within 45 days from the date on which the measures had been taken. It's a matter, my lord, they approached the DRT and, my lord, they filed an application challenging my sale notice. My lord, DRT refused to grant. My lord, in case, my lord, they're aggrieved, then, my lord, order passed by the DRT, they have to go under section 18. Section 18 says, my lord,
appellate
authority, if they're aggrieved. No, my lord, instead of approaching the DRAT, they came before this honorable court. My lord, they're making the very same contention which is canvassed before the DRT.
Is that content in learn a single judge?
No, my lord, the very same contention, because it's nothing but a forum shopping, my lord, from the respondent number 1. The very same contention canvassed before the DRT, they're taken up before this honorable court and taken an interim order. Obtained an interim order. And pursuant to that, my lord, they withdrew the securitization application without informing me. And my lord, they're pursuing the matter before the learned single judge. My lord, my respectful submission in this matter too. One is the right, my lord, DRT is a competent court to decide the matter if I'm any violation which I taken by me. The second submission, my lord, DRT is not granted interim order. They have to go under section 18 before DRAT. My lord, in fact, I filed a compilation judgment before this honorable court. I just, my lord, point out.
So that is the argument to be canvassed before learn a single judge, not here. That is the whole point. You will be entirely right on merits.
In fact, my
Your
lord,
argument may be acceptable.
I'll just.
As a appellate court at this juncture, not
my lord,
going to
kindly
interject
come to
also.
page number 34 for a moment, my lord. I pointed out the very same point before the learned single judge. Page number 34 in the, my lord, in my appeal. The last para, 34, my lord, last para. Learned counsel Shri Vignesh Shetty would submit that the petitions are before the DRT. The same cause of action in essay number 33 of 2024. The matter was listed on 23/1/2024. The interim order was not granted and the matter stands adjourned to 29/2/2024. The moment the interim order was refused, sale take place. The moment sale take place, even before the ink on the same would dry, the sale certificate issued in favor of the auction purchaser and the registration of sale certificate also taken place. All these factors would undoubtedly merit entertain the petition. Since the Learned Council projects ballotant authority aberration in the case at the hand, notwithstanding the pendency of the proceeding before DRT, I deem it appropriate to entertain the petition as the facts are so glary that would merit such entertainment. In the light of the sale already taking place and the sale certificate being issued, status quo, the nature of the property be maintained by the parties till the next date of hearing. My lord, I'll just rely, my lord, two authorities. In fact, I filed a dates and events synopsis before this a list of authorities before this honorable court. The first authority, my lord, at page number 1, the United Bank of India versus my lord Satyavati Tendon, my lord, it says that my lord DRT is a competent court. If against that, my lord, they have to go to DRAT. That one judgment, my lord, at page number 32, passed by this honorable court. In the very same aspect, my lord, where my lord, they're supposed to go to DRT, page starts from page number 32. My lord, page number 44, the relevant, I'll not trouble my lord reading entire judgments. Para 12, we have considered submissions made on both the sides and perused the records in United Bank of India versus Satyavati Tendon. The Supreme Court, while setting aside the order passed by the Division Court of the High Court in entertaining the writ petition against action taken under Section 14 of the Act against a defaulter in paragraph number 43, 44, and 45 as under. But I'll just skip it. And my lord, later, my lord, they relied, my lord, the State Bank of India SPT versus Matthew Casey. The Supreme Court once again reiterated that before passing an interim order, the caution required as expressed Satyavati Tendon Supra has to be taken into mind. In view of the aforesaid enonication by law, by the Supreme Court, it has to be ascertained whether the instant case is a fit case in the extraordinary discretion of the jurisdiction of this court should be excised notwithstanding an alternative efficacious remedy. Nothing has been placed on record to demonstrate as to why the alternative remedy of appeal is not efficacious. In the facts of circumstance of the case, all contention raised in this appeal can as well as raised in the appeal before that particular tribunal. Besides that, the learned single judge in excess of discretion jurisdiction has refused to interfere in the matter and regulated the appellate to the appellant to alternative remedy of an appeal. A division bench of this court in case so and so KSRTC versus Karnataka State Transport Authority has held that it may be not too appropriate to interfere with the discretion exercised by the learned single judge in an intra-court appeal unless it is shown that exercise of discretion is arbitrary. It is not the case of the appellant that exercise of the discretion by the learned single judge is arbitrary. Though many contention has been raised before us, however, we are consciously not dealing with the same, as the same would prejudice to the right of the appellant of the prosecute the remedy of appeal. For the aforementioned reasons, we affirm that order passed by the learned single judge, however, the appellant is granted the liberty to approach the Detrico tribunal by filing an appeal within a period of 3 weeks from the date of receipt of the certified copy of the order passed today. It will be open for the parties to urge all the conditions before the Detrico tribunal. My lord, it is a case wherein, my lord, that bank sold a property. Pursuant to that, my lord, the borrower, my lord, paid the entire money. In fact, my lord, I got an opportunity to assist the honorable court. Entire money has been paid. Even though, my lord, this court said that you have to go to DRT. My lord, all the contention which is subject before this honorable court, that very same contention he can raise before the DRT under section 17. That is a, my lord, settled position of.
Very same condition you can raise before learned single.
No, my lord, when, my lord, remedy is available under section 17.
So point out to learned single. This is only tentative
In fact,
finding. This is an interim order granting stay up to next date. Whatever recorded is not a final finding. A tentative opinion of learned single.
In fact, learned single.
There is no reason that the learned single is not open to consider all the arguments, including the argument that.
In fact, in the order, it is recorded. I'm so sorry.
Yes.
In fact, in the order, it is recorded. I pointed out, my lord, the matter before the DRT and
will say that this is only tentative finding. We'll verify that this order, these findings are only tentative. Whatever recorded and observed by learned single judge in the interim order is necessarily tentative findings.
I'll just put it in this way, my lord. It's a fact, my lord. They are availed alone. It's defaulted. I issued a 13 for it is not in dispute and issuance of sale notice also. My lord, there are 5 bidders participated in the auction. It's a public auction. 5 bidders, my lord, participated. My lord, in fact, my lord, now, my lord, they're taking only one contention saying that, my lord, the property value is less. That's the only one. That is the only one contention.
Lordship, we have filed, my lordship, the application for initiating contempt against the valuator. because he has filed, my lordship, false affidavit before the honorable court. My lordship, he is not having qualification to will not value the plantation property. Either in respect of that, my lordship, he has filed that he is having qualification. And further, my lordship, there are the learned single judge has taken note of two aspects. Why, my lordship, property has been valued, my lordship, less than the, my lordship, the government value. Why, my lordship, the SR value itself is 7 lakhs per acre. They have valued it at my lordship 1.25 lakhs. And another aspect is, my lordship, that the valuator has no qualification. My lordship may produce this. Lordship, these documents.
You are committing same mistake,
Sorry.
arguing the matter on merits, which we are not going to. We are not going to enter into any part of the merit.
Please, I'm sorry.
Dismissed, relegated back to the learned single judge, only on the ground that interim order with clarification that the all findings are tentative, will pass the order. Require the party to approach learned single judge with a request that this may be taken up expeditiously. Yes. We'll note your argument about the alternative remedy before the tribunal, and we'll say that whatever observed by learned single judge net regard is and will be tentative. It will pass the order. Dismissed. We'll be in the recess.
Number 14, Shyamshiv Prakash.
Not I appear for the
My lord.
government, my lord.
Appeal for the central government, my lord's last date of hearing. Last date of hearing had made submission that whenever the express highways are constructed, there bound to be some inconvenience hardships would be caused to the locals. Is there any genuine reasons that they may approach the project director where any possibility of finding a solution or way out? That's the only thing what I have said.
You are finding some way out.
Lordships.
You want to find out some way?
No, if it's available according to technical specifications, they only the director can take a decision, not with.
Take decision.
Our director is up. One Miss Shilpa Shah appears for NHA director. I think she is online.
So you want to find out some way for him?
No, no.
Going to-
They have to approach if he considers.
Approach.
That's it. Court cannot. May I please, Mala?
Few facts are very necessary.
Say that once you
Now, he says for the past 1.5 years, they say is only by say. Nothing, they have either the remedial measures they have not worked out. First point. Second point is already a technical team and the deputy commissioner of the Bangalore Rural District, he visited on our representation in the last week. And he made an inspection and also given report to the government. What is the ground reality and what is the problem and how it affects. Few facts are important. Mala. May I kindly take para 5, 6 and 7?
We
Because-
disclose, on the last occasion, we
Mala,
disclose our.
with due respect, I have looked into that judgment rendered by the sample court. Facts are totally different. Facts are
Facts,
totally.
we are on principle. Facts may.
No, I am not seeking any relief.
People never varies.
No, I am not seeking any relief to that authorities to do this thing or that thing. My relief is only a grievance, a public grievance, where a large number of people have suffered and they will suffer it. Few facts, para 5, 6, 7 I will read. Then afterwards I will take annexures also, my lord.
So you are saying that they were present good access
May I read, my lord?
from National Highway Road,
Where?
Bangalore to Vellore. National Highway 75.
National Highway 75 is a connectivity road since decades we are using it. And we have no objection. Now, this corridor road project, they have proposed it in the, this is brainchild of Bharat Ratna late Atal Bihari Vajpayee. We have no objection for this corridor road. But after the project is.
You are saying that Bangalore to Vellore should not be disturbed.
Bangalore to Chennai road. And now the road leading from Bangalore to Chennai, that is NH 75 is the road which connects to our villages.
At least I am never a good planner.
No, I will explain, man. Now, I am also not a good planner, but only thing is, Now, the judicial remedies where we are approaching.
If we go on adjudicating such kind of matters, we will know time to revert to.
My lord,
crops.
kindly, it's my appeal to my lord, kindly bear with me, few minutes. I will explain, demonstrate what is the inconvenience caused to the larger number of 20 villages, and how we have made a representation, how it has been ignored by these authorities. Now, after hearing the matter, this honorable court on 1/3/2024 issued the notice for calling upon them to give a statement, 1/3/24. My lord, page, the para 5, I would like to read and I would like to impress upon this honorable court.
Paragraph.
Para 5 of my petition, my lord. It is in page number 13, 1/3. My lord, the village Kolaturu is one accredited progressive village for the reason that animal husbandry industry is more. Presently, the village population of the hybrid cattle are more in the village. He is recognized in number 2 in the Bangalore district procurement of milk and name of milk society, Karnataka Milk Federation. Federation Society. The supply of milk is more than 5,000 liters per day to KMF and to the private dairy about 500 liters. The agriculture and horticulture produce, namely the green grass and cattle, vegetables, fruits, flowers are also transported to the Bangalore, nearby cities in south side and Kolar and nearby cities in the north side from 20 villages every day through the connectivity road of Kolattur to NH 75. Few photographs of animal husbandry in the village so produced before the annexure D series. The petitioner submits that there are number of well-established schools from the primary to 10th standard in the village of Kolaturu and other villages having connectivity of Kolaturu main road. These schools are government schools which are established in 1950s. Added to this, there are private schools catering education to the rural children. Further, to facilitate, support the farming community, an extent of 80 acres of land has been acquired by corporate company to establish warehouse, cold storage. For this establishment, the only link road is through Kolaturu main road. The district authorities, Department of Health and Family Welfare also identified the village Kolaturu to establish a mother and child hospital and sanctioned rupees 35 crores. It is a mega project and the construction is almost near completion. It is called District Mother and Child Hospital. Few photographs evidencing so and so. The petitioner submits that the manner in which the corridor road loop and service roads are planned en route Kolattur village is here with produced and marked at annexure F. As may be seen, the link road, loop road is provided for the vehicle movement from Kolar and Bangalore to join the corridor road. These loops marked ABCD are blocking the road of Kolaturu from going to Bengaluru and Kolar side, in addition to Doddaballapura side. The present Kolaturu main road is in use since time immemorial and was connected to NH 75 for its uninterrupted use in all 4 directions. The very object of forming national highway and other roadways is to the benefit and use of public at large, including social and locals. However, user construction is used to use immense inconvenience and problem to the locals of Kolaturu and 19 connected villages. If allowed, it is equally important that public at large, nearly 10,000 to 15,000 population of 20 villages are affected in free and easy movement as is existing before the construction of flyover. That only road connectivity to NH 75 for the 20 villages is Kolaturu road, which will get blocked. It is pertinent state that per day movement of vehicles, which includes passengers vehicle, 4-wheelers and 2-wheelers, the goods vehicle, trucks and so on, so about 8,000 to 10,000. And this road is also having connectivity for movement of petroleum loaded vehicles nearby Indian Oil Corporation stock yard called Devanagundi. The movement of vehicle in the road, Kolattur, few photographs so and so are produced at annexure series. The most important thing is the district mother child hospital. The pregnant women and infants are brought to the hospital in most of the cases with emergency. The movement of vehicle to the village and inside the village to be provided with easy and trouble-free access so as to prevent any untoward incident as contingent event. Mother is brought to the maternity hospital home during last period of pregnancy or gestation period. The hospital being recognized as a child and mother hospital, Government of Karnataka having constructed with a budget of 35 to 40 crores. The obstruction to the road of Kolaturu certainly would cause unbearable inconvenience to the general public with cases of maternity child care. Traveling from Taluk of Devnalli, Nelamangala, Doddabalapura, Hosakote, and Anekal. This aspect has not been taken into consideration by the national authorities so and so while forming the proposing construction of a loop and link road. Not only important but most essential is to revise the so and so and provide free and easy access in all directions between the existing Kolattur main road and NH 75 and NH 648, in addition to form the Bangalore Chennai Express Corridor Road. An highway transportation expert may be appointed by the humble court to coordinate with the concerned authorities who shall, with PWD also, who shall process the feasible plan scheme that can take into account the future expansion of the existing Kolattur main road and any other roads under implementation by both the highway authorities and the state government. This is facts, my lord. Further, I have also stated wherein a representation is made in the month of September 2023. It is at annexure A, my lord.
Yes.
My lord, representation made way back in the year 2023 in the month of September. The main project of this Bangalore Chennai corridor is completed. Now, so far as that project is concerned and the clearance is concerned, there is no objection. Now, the deviation in causing this loop road to this village main road, they are obstructing.
That is all.
There are two reasons. One is now as far as the notification is concerned, acquisition of land to favor one or the other two persons, they have deleted few item of the survey numbers 272, 172 and 171 nearby our village. That has led to this problem. Now, if they have acquired and if they have completed as per the previous project and project what they have conceived, that would have been the only thing which were they have provided all these things. Now they have deviated. Deviation of by deleting or by omitting these two survey numbers 171, 172. By deletion of those two lands, cause this inconvenience by deviating the entire project. That's one point. Well, there are one or two grounds where I want to impress upon this sample court. The ground is that I made a representation. The authorities, they shall consider my representation Article 350 of the Constitution.
Then withdraw the petition and go before the.
Well, when the authorities failed, when there is a failure on their part, now I am before the sample court seeking a proper direction to.
We're giving the direction. If that much direction you want, we will be giving, provided you withdraw the petition, not in the petition.
My lord, because we are with robust experience, my lord also had an experience, these persons, the authorities, how they act whimsically. Now, if I withdraw it, and these authorities.
Don't withdraw them. The option is yours. Exercise the option. Either you invite order or go for representation, pursue the representation.
My lord, my representation at annexure A is to be considered is my prayer also. May I kindly take my prayer column also, my lord?
If you are wanting that much prayer, we can grant it.
My lord, that's the prayer which I have sought, and they shall not keep that my representation in a cold storage for months and years. They shall.
So either you pursue this petition or pursue the representation. Choice is yours.
My lord, my say, prayer is also, it includes the
Prayer we have
comprehensive.
seen, prayer we have seen, again we will see it at your
My lord.
instance. Yes.
Prayer 2 is issue writ of mandamus to consider the representation at annexure A, dated so and so, and to pass appropriate order and respondent National Highway Authority submitted so on to prepare best suited schematic plan for the Kolathur junction so as to ensure uninterrupted all-time free and easy access in all directions to the villages of Kolathuru and other 19 villages from to the National Highway 75, National Highway 6 and 48 and Bangalore. This is one representation, my lord. And also I have second prayer I sought is appoint highway transportation expert may be appointed by this honorable court to coordinate with the concerned authority who shall propose the feasible plan scheme which takes into account the future extension of the existing Kolathur main road and any other roads under the implementation by both highway authorities and state government. This is the two prayers which I said. My lord, on the last date of hearing, with due respect, my lord referred the judgment of this honorable court where my lord has rendered it. I have gone to this judgment, my lord, where widening of the road, where the villages have the objection. At that time, of course, in the widening of the road, this honorable court said we cannot do all those things and we are not a technical person. Now here is a case where the flyover is over and it is set out for use also. Now a loop road which in the earlier plan also I placed, my lord, that they have deviated. Where there is a deviation, even National Highway Authority rules also says that there must have an approval. Rule 17. Rule 8, my lord. Rule National Highway Authority in 1957 where deviation in work, substandard work and completion of report. The executing authority shall not, the executing authority is these contractors, they are the agencies. In order to save money and in order to make money, these are the, to say shortcuts, these methods are used by these executing authorities. The fault is with the executing authorities where the original plan which the authorities have finalized, National Highway Authority, they are not doing it. That was the thing which I brought it to the notice of the authorities. They did not look into it. And second thing is some person for extra reason, two important lands which have been deleted. Further, I cannot have anything to say only what is extraneous purposes. These things, how they have deleted and why this deviation from the original plan. Now, section A, rule 8 of National Highway Authority says the executing agency shall not without
They
the.
have told you that we are not inclined to enter for public interest petition. You go on arguing as long as you can.
My lord,
then the order will follow will be equally long and strong.
My lord, because there is a grievance, public grievance, that's why I am making my.
We are not inclined. That is all.
My lord,
Last time you told you, today we are telling you. Option is yours. Either you pursue this petition or pursue the representation.
My lord, there are where in a public interested pro bono public, where the humble apex court looking at the judicial activism, where two wings of the government when they fail, then this court can, this
In
court.
proper cases we do entertain, but not in this case. Planning highways is not the function of the court.
My lord, I am not asking planning. This is.
Incidental inconvenience is bound to be there.
My lord, it's not incidental. It is not incidental. It is a grave injustice caused and also inconvenience for 19.
That is your perception.
Not perception. I placed all the material documents because I am not for any to say a personal relief. I am not before this. It is 19 villages of 20,000 population, and moreover, this is the number 2 in the entire district and state procurement of the milk. Procurement of every day we have to move this milk from the village of 19 villages to the Bangalore city as well as to the other parts. This is the only road. Connectivity to 75. Now this loophole they are causing this obstruction. That's the grievance of the entire 20 villages of 20 or more than 20,000 village population. That's my grievance, my lord. There is no personal interest or private interest. These are all agriculturists and persons who are there for 2, 3, 4 generations in the same village. Now there is apparently the authorities have either willfully they have not considered my representation. That has to be considered.
To pursue it.
Please, ma'am.
Pursue the
No, because it's a grievance, my lord, because it's not for my satisfaction, I'm not arguing. It's a grievance of the villagers. Because The way in which we're all from the rural side, we know what is the everyday difficulties we are facing. And the one of difficulties when they have come, it is my humble duty to present it before my lord.
AG's office.
We have heard you. So are you insisting the order to be dictated here?
My
or
lord, I insist because
Here. Here. Or we can do it in the chamber.
you can,
Your
you can,
choice.
it's, my lord, left to my lord.
Lordship,
Because it's,
Any grievance?
no,
my lord,
no grievance, man.
About dismissal?
No,
of-
no, no
my lord,
grievance.
so far as this government is concerned, they will not, because notice issued after hearing the matter at length, they are keeping silent.
You want to pursue representation, then we'll permit it.
That would be appropriate, my lord.
Then you will to go
Yes,
for
yes.
representation only, not the petition.
Yes.
My lord, authorities how they act, every day we are coming across.
Then, sorry, Mr. Dismissed. You want, now you, third option, you want cost or don't want?
My lord, I want detail order.
That will pass. You
Please,
want-
my lord.
That will pass. You want us to pass right now, we can pass it. The choice is yours.
No, I leave it to my lord because one or two citations I refer,
So that we are only saving time so that every matter reaches.
Yes.
There is no other reason not
Please,
to
madam.
dictate here.
Please, madam.
If you want the order to be dictated right now, we are proceeding. the order.
I leave it to my lord because.
No, we leave it to you, sir.
No, because time is valuable and precious. I leave it to my lord. And government's silence is to be taken into consideration, my
Third
lord.
learned advocate.
My lord,
Mr.
then
Soam.
in that case, cost may be imposed and may be given to the Advocate General's office, my lord.
No, you cannot advise all these things, madam. You are an experienced advocate. When the public are before the sample court, grievance, cost is not the remedy.
Third learned advocate, so and so was the petitioner from a learned additional advocate, government advocate, Ms. Neelofer Akbar, for respondent and its authorities, and learned advocate, Mr.
Kumar Emin,
So and so for
CG SPC for respond number 1, Union of India.
this one number,
1, Union of India.
National Highway Authority.
No, no, Union of India.
Union of India.
Yes.
Who? Union of
Respond
India.
number, NHA, there is one advocate by name.
I sought a copy on them
Shah.
also. I sought a copy on National Authority, learned advocate also, Shah, Srimati Shah.
He is not here.
They should cooperate with the court. They will not.
What can be done?
My lord, for rendering justice, everybody should cooperate and they should assist the sample court to render the true and effective justice.
Many are not cooperating.
That may be taken note, my lord.
What?
That may be taken note because this is the third time they are not appearing. I served a copy. I have acknowledged it.
Those who want to appear, welcome. Those don't want to.
No, appearance
Then
is,
more welcome.
appearance is to assist the sample court ably to render the justice, my lord. That's my concern. That's my endurance, not with any other meaning. I'm making submission.
The petitioners, 13 in numbers, who claim to be public spirited persons, have filed this petition, styling it as public interest litigation. What is prayed is to all for the record and material in respect of the project of construction of highway named Bangalore-Chennai Corridor Road and the junction at Kolathur. A writ of mandamus is prayed against the respondent National Highway Authority of India, indicate NHAI, to prepare best suited plan for the flyover at Kolathur Junction and to ensure uninterrupted free, easy access from all directions to the villages. Yet another prayer is made to appoint experts in the subject of highway and transportation to coordinate with the national NHAI and other authorities to prepare the feasible plan. Paragraph, the case of the petitioners is inter alia that the Bangalore-Chennai Express Corridor Road is already under construction. It is stated that the said road was conceived in the year 2015 and the preliminary survey was conducted. It is stated that now the work has started. The petitioner's case is that the villagers of the Kolathu and other connecting villages have appealed to the highway authorities that they have presently good access to and fro the National Highway Road Mangalore to Vellore NH-75. It is the grievance paragraph. It is the grievance of the petitioner that the said good access might get affected because of the construction of the Bangalore-Chennai Express Corridor. It is the submission that the same should not get affected by the proposed construction of the expressway, which is taking off from the new National Highway Road, NH 648. The petitioner wants the paragraph authorities to ensure that the road may not be obstructed and a suitable flyover may be constructed to ease out the movement of general public. Full stop. The petitioner has stated that the construction of the express corridor may result into inconvenience to the
One factual small, express highway road is completed.
in the dictation of the order, we are not going to tolerate any interruption.
My lord, I am not obstructing, it's only clarification.
No
The
clarification.
highway
Any
is
error
over.
you go, while court is dictating the order, I am not tolerating any interruption.
My lord, I'm sorry, factually, I just said, it is over. The highway corridor road is completed. It's only a loop road, they are causing this thing. Highway road, it is completed. There is no objection from the villagers or anybody. It's only a loop road which they are now connecting. It is causing obstruction.
It was submitted that the express highway is already completed.
Completed.
And the loop road is being
Correct.
constructed, which may affect the movement of the village people. Full stop. It is on the premise of above facts and submissions, comma, the prayers as above are made, and it is stated that the flyover under construction may cause inconvenience and problems to the local residents. In course of the hearing of the petition, the petitioner was specifically, learned counsel for the petitioner was specifically asked whether the petitioners would opt to pursue the pending representation with the authorities. Full stop. It was stated that the petitioner would opt the other course and would invite the order in this petition. Full stop. The grievance about the manner and the layout of the loop and the construction of highway cannot be entertained in public interest petition. It is essentially an executive function. Full stop. In what way the highway and the loop is to be constructed, where from it should pass, and what should be designed are all These are all the aspects in expert domain for which the court has no role, much less expertise. Full stop. Highways are generally for public good. And when highways are constructed, incidental inconvenience do occur for the nearby residents. Full stop. The ultimate object is to promote the public good and smooth movement of traffic. Full stop. Construction of highway cannot be subject matter of public interest litigation. Full stop. In Sri IRANA, IRA versus Union of India, which was writ petition number 520 of 2024, and also public interest litigation, this court, the division bench of this court observe that the public interest jurisdiction of this court does not extend to all categories of cases, then quote paragraph 5.1 from this judgment. It was further observed that the public interest litigation has to concern the class of people such as bonded laborers, under trial prisoners, prison inmates, and such deprived class of the society. Full stop. Judicial intervention through public interest litigation may be necessary for protection of the fundamental rights and to ensure the smooth functioning of the democratic institutions. Full stop. Every subject matter, such as construction of road or construction of highways, do not fall in the category where the public interest domain can be exercised by the court. The publication is paragraph. It was further observed than quote paragraph 5.3. The decision of the Supreme Court in Guruvayur Devaswam Managing Committee versus C.K. Rajan, 2003, 7 SCC 4 546 observes thus, then quote this observation, paragraph 67. About the laying down the road, the court held thus, and quote paragraph 6.1. The project of construction of highway cannot be interjected in any manner, since it would, on the contrary, work against the public interest. Full stop. The directions of the kind and nature prayed for in this petition would hardly be given. No writ of mandamus could be issued as prayed for. Full stop. The present public interest petition is thoroughly misconceived and is dismissed with cost of rupees 15,000.
Well, at Article 350, I mentioned it kindly. 350 about representation to be considered. Article 350 of the Constitution, where a representation given, that has to be considered by the authority. Well, on the other day when
we gave you the option in the beginning.
Well, when we are given it in the way back, about 1 year back, and
this court of law, we can't go on hearing like you.
When they are not represented.
Any land. Sorry.
Well, at 350 is to be mentioned because I may take.
We told you we want to pursue representation, then go. Either pursue this petition or pursue your representation. We did give you the option in the very beginning, right from the beginning, even the last occasion.
My lord is gracious to give the option, but our problem is when we have made such a representation long back till date, they are not, it is kept in the cold storage. That's what we are now before the sample court seeking a mandamus. And that's what representation to be considered the clearly the article 350 says, because on the other day, in the similar matter, where the lordship, when I was sitting, Krishna Dikshit, when such a representative.
You, sir, that we are going to issue direction to them to consider in accordance with law, your representation.
Well,
You
even
said
now,
no.
even now, first prayer.
So many words in
My
very
lord,
expressly.
my humble submission is, even now, first prayer, if this honorable court is not prepared to consider.
Till the option is open, you want, then we will not take trouble of writing the order to your disadvantage. You want to pursue representation? This is final.
My lord,
No.
my appeal is that I will pursue my representation with
Then
a,
you withdraw this.
no, with the time bound direction may be given, my lord.
Then you withdraw the.
I will withdraw it with the time bound directions, my lord.
So after wasting so much time. of
My
the
lord,
court.
it's not wasting, it's a for justice.
He's wasting, Mr.
No,
Thompson.
we are fighting for justice, my lord, where injustice has been caused by these authorities.
We are not in the habit of entertaining the debates on every issue.
My lord,
When we
only,
say it is a wasting of time, it is a wasting of time. And it is
Only-
fortified by your withdrawal of the petition.
this court with iron hand can deal with these executives, otherwise
What do you-
nobody.
Now the option is yours. What do you want?
My lord, I said, I'll pursue that representation.
You are withdrawing the petition
Definitely, I will file a memo and with the time bound direction, my lord.
after arguing the case for considerable long time. Learned advocate Mr. So and so seeks permission to withdraw the present petition stating that the representation dated 4/9/23, which is pending before the which National Highway Authority
National, all authorities,
National
before
Highway
all the
Authority.
authorities, respondents.
may be directed to be decided by the authorities. It was expressed that the petitioner would opt to pursue the said representation. Full stop. Paragraph. The request is reasonable. The petitioner is permitted to pursue the representation. The competent authority respondent shall consider the said representation and render its decision in light of the facts of the case and in accordance with law within a period of
8 weeks.
8 weeks from today.
Highway authorities.
It's only NHA. madam.
National
NHA
highway authorities have to give.
The
NHA
representation
is the
given
authority who
respondent
has to
number 4
respond to
also.
that matters, not other authorities. He has addressed to
Very good.
Acquiring authority is government.
Within what time will decide? 6 weeks?
that I don't represent NHA. She is not before this court. Who represents NHA? She is not here. madam.
Doesn't matter.
Maybe reasonable time of 8
The
weeks.
respondent shall set the representation within 8 weeks from the date of receipt of this order. Full stop. It is clarified that this court has not gone into or expressed anything on the merits of the case of the petition. Full stop. The representation shall be decided by considering all the facts and in accordance with law.
Right, my
On
lord.
that.
That's only one submission matters.
Stop anger, I may speak, it's only in the court spirit and, my lord,
Pardon?
the pit up argument, I may be anger because injustice.
You
has
have
been caused.
forgotten why you are reminding me. You have forgotten everything after this order.
That's just only one submission matters.
Government educated stand is
The-
not correct. Imposing
As far as
cost.
All
say,
right, I
direct-
really
sorry.
don't understand why I'm attacked. They say if I keep
Yeah.
quiet, they say
No,
I'm
if it is a privilege,
silent.
then you
My
can.
lord, if I argue before my lord, they say I quarrel with them. I have
No,
to
no.
safeguard my clients, my lord. I don't know what I'm supposed to do.
It's not a privilege.
You don't draw exasperation from from us.
Stand is not correct. I deprecate.
let's just, may I draw the-
My lord, in a jovial manner, I said it would go to the Advocate General's
General's
office. My
office.
lord, we have no such funds. But in a joking manner, I said that. When my lord said, my lord would dismiss it with
No,
cost.
serious matter is not a joke, madam.
What is the
Let's-
serious matter? We have nothing to do in this. It's the National Highway Authority.
Take it lightly.
No, if it is.
So you should take all angers lightly,
My lord,
including
if
courts.
it is a frivolous, then what my learned friend says is correct. When we are
Yes.
genuine cause when we have come, this is not the statement. I'm highly obliged. my lord.
That's just only one submission matters. This direction may be against respondent number 3 and 4.
No,
Competent
representation
authority.
given to
To
all.
all, but-
Even a revenue authority is also important. Deleting
one-
two.
My
or
lord,
three.
I'll see that it is considered, my lord.
Yes, next.
Appearance matter, seal number 15, Mr. Chandranath Arika K.
For the complaint. Lord, the matters today for appearance of the respondent accused number 1 and 2, my lord, they are before your lordship. Lord, their husband and wife, my lord,
My lord, appearing for the complainant, may I bring few facts to the.
my lord, today it's for appearance, my lord, may I submit. But earlier on, my lord, 20 to 2024, the order of the Honorable Court. But the direction is at page number, my lord, 26.
So Tehsildar is to take action.
Please, my lord.
Tehsildar is to take action to remove.
Yes, my lord, it is for the respond number 3, direction is given. But nothing against my lord R1 and
My lord,
R2, my
my
lord.
lord, I am the complainant.
They are
I am
appearing,
the complainant.
but I am answering lordship. My lord, today, for appearance, it is posted, my lord, there before a lordship. The direction is, my lord, to form a road. My lord, it is already formed.
So you ask somebody to remain present. Who are they?
My lord, these people are private persons. They are not the touch.
Who are bringing
My lord, the allegation now, my lord. Allegation is that, my lord, she has obstructed.
My lord, this matter was
Obstructed
heard,
formation of the road.
this matter
My lord,
was heard several
there is
times.
no obstruction. Road is completed and handed over.
Not correct. I will draw my lord's
Who appears
attention.
for Tehsildar? Who will appear with Tehsildar?
That is Panchayat Development Officer.
Direction against you.
That is PDO, my lord.
Tehsildar Belthangadi Taluk is directed to complete removal of entire encroachment of government land surrounded by 554 1C1 within 4 weeks. So,
I'm for the accused number 3. The complaint does not make the Tahsildar a party. Accused number 3 is the Gram Panchayat.
I'm not.
that is party.
He's not a party in the contempt petition. He's a party in the
Not
original
in
proceeding.
party.
My lord, before that.
But
would your
then, my
lordship-
lord,
would-
direction is
Lord,
there. Communicate the order to the Gram Panchayat. My
My
lord,
lord,
later
being the
portion of that
complainant-
order.
My lord, appearing for the complainant, may I bring it to the notice of the court a few aspects, my lord? Few aspects.
You have made a not party, Tehsildar a party.
No,
The direction
Tahsildar is
against-
not a, Tahsildar is not a
The
party.
basic fundamental thing you are missing.
My lord,
The direction is against Tehsildar, who is not a party. So on that ground, this contempt petition is disposed of as not surviving.
my lord,
With a liberty to file press contempt
my lord,
by arranging appropriate parties
my lord,
who are there before the learned single judge in the writ petition.
these other two were parties before the, before
Other
the
two are
letter-
not concerned. We are not concerned. Is there any direction against other two? Very basic things, Mr.
No,
Counsel.
no, my lord.
You are
I
a
will-
very well experienced
No.
counsel.
My lord, there is obstruction, there is
Carry
obstruction.
the direction against the private persons.
No, these private persons were the parties before the court. Kindly see the cause title at annexure A, page 8.
We are concerned with the direction, not the parties.
No, direction and the obstruction. Gram Panchayat, my lord, the Gram Panchayat is direct, Gram Panchayat, that he has to do, he shall also communicate
Plan
this
to sit down.
order to Gram Panchayat.
Yes.
My lord, may I bring it to the notice of the courts? Few facts, my lord, few facts.
The only facts necessary in the contempt jurisdiction is the
No,
direction and the
because,
authority against whom the direction is.
my lord,
issued.
these,
Nothing more is relevant.
my lord, kindly see the order, my lord, kindly see the previous order. Would your lordship kindly?
This order, we are not concerned. We are
No,
concerned with the present.
previous, the matter is listed slated for hearing before charge. And the accused number 1 make a scurrilous attack against the judges. My lord, matter was heard before this honorable court. On the next day, he goes out in the open and makes a scurrilous charges, and a pen drive is placed before the court. The advocate admits that such a thing has been done and apologizes for it. And the apology is taken on record. My lord, kindly see that portion of it. Kindly see that portion of it which is recorded. And repeat, sorry, my lord. And repeatedly, my lord, after being warned, repeatedly he makes these scurrilous attacks. And this honorable court, the judges of this honorable court asked him a question. Next day, he goes out in the open, that is a public speech. He says, who are the high court judges? How can they deal with it? All that was placed before the court, and the court asked me to place the pen drive before the court. The advocate also admitted that it should not have been done. And apology letter is memo is filed, affidavit is filed. And it was done previously, my lord, 3 times. All these facts are before this honorable court, placed before this honorable court. My lord, kindly permit me to read a few of these, the earlier orders of this honorable court in the very same contempt proceedings. My lord, kindly see the order dated 3/1/2024.
You got it, 3/1/20.
Yes, ma'am. He is not happy with the manner with which the statements have been made by the accused number 1 in the video. He further submitted that as an officer of the court, he would advise his client to tender apology. In the alternative, pray this court to take such action as deemed fit. His submission is placed on record. My lord, that was taken on record. A affidavit was filed. My lord, after the affidavit was filed, the matter was again listed before this honorable court on 20th, my lord, 22/2024.
Yes.
My lord, on that day, accused number 1 was present physically. The court asked him a question. How much you have studied? How much you have studied? He says up to 7th standard. My lord, 1 minute. My lord. It did not stop there. Then on the next day, my lord, would your lordship now go to the memo which is placed on record with the pen drive? With the pen drive, kindly see this memo, my lord. It was filed before this court on 27/2/2024. My lord, it is placed before this honorable court with a memo and the pen drive dated 27/2/2024. My lord, what he has said, my lord, it is in Kannada. If I am permitted to read, I shall, and also provide the English translation of this. Kindly paragraph 3. Paragraph 3. This honorable court has specifically directed accused number 1 to honor the orders passed by this honorable by the courts of law, and failing which stringent action will be taken against him for having posed him question by this honorable court. The accused number 1, by showing utter disregard and disrespect in a public speech made on 25/2/2024, that is after 4 days, he has made the following comments. My lord, it is in Kannada. If I am permitted, I shall read it, my lord, and translate it. ಒಬ್ಬ ಜಡ್ಜ ಹೇಳ್ತಾನೆ, ಎಷ್ಟನೇ ಕ್ಲಾಸ್ ಕಲ್ತಿದ್ದಿ? One judge asked me about my education qualification. ಏನ್ ಹೇಳ್ತಾನೆ ಜಡ್ಜ? ಅನ್ಎಜುಕೇಟೆಡ್ ಅಂತ ಹೇಳ್ತಾನೆ. ಹಾಗಾದ್ರೆ ಅವನ ಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ನಡೆಯೋದಿಲ್ವಾ? Can I not proceed against the judge for contempt? Is what he said. ಅರೆ, ದೇಶದ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ, ಫಂಡಮೆಂಟಲ್ ರೈಟ್, ಎಲ್ಲರನ್ನು ಎಲ್ಲ ಹೊತ್ತಿನಲ್ಲೂ ಅನ್ಯಾಯವಾದಾಗ ಈ ದೇಶದ ಕಾನೂನನ್ನು ತಪ್ಪಿ ನಡೆದಾಗ ಪ್ರಶ್ನೆ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿದೆ. ನಾನೆಲ್ಲ ಹೇಳಿದ್ದು, ಮಹೇಶ್ ಶೆಟ್ಟಿ ತಿಮರೋಡಿ ಹೇಳಿದ್ದೆ ಅಲ್ಲ. ನಾನು ಒಬ್ಬ 7ನೇ ಕ್ಲಾಸ್ ಕಲಿತಂತಹ ಅವಿದ್ಯಾವಂತಹ ಹುಡುಗ, ನಾನೊಬ್ಬ ಒಪ್ಪಿಕೊಳ್ತೇನೆ. ತೆರೆದ ಕೋರ್ಟಿನಲ್ಲಿ, ದಟ್ ಹಿ ಸೇಸ್ ಇನ್ ದ ಓಪನ್ ಕೋರ್ಟ್, ಒಬ್ಬ ಜಡ್ಜಿ ಹೇಳ್ತಾನೆ ಅನ್ಎಜುಕೇಟೆಡ್. ಹಾಗಾದರೆ ಅವನು ಯಾರು? ಹಿ ಸೇಸ್ uneducated, then what is he? ಈ ಜಡ್ಜಿ ಯಾರು? ಈ ಪ್ರಶ್ನೆ, this question I am openly asking. ಇನ್ನು ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಡೆಲ್ಲಿಯಲ್ಲಿ ಕೂಡ ಮಾತಾಡ್ತೇನೆ. My lord, all this scurrilous attack on the judges in a contempt petition, not once, my lord. I have placed before this honorable court the other papers. Kindly see the documents placed before the court on earlier occasion, my lord.
I will consider. You are not pressing the direction against the Tehsildar.
My lord, the Tahsildar, I have not, because,
Not.
because there is a
Very well.
direction.
You are not pressing.
My
Not
lord,
pressing
direction.
that part of the direction.
My lord, I would, my lord, I will make an application for impleading because please, my lord, I shall. Because direction by this honorable court is specifically to the Tahsildar and the Gram Panchayat to execute it. The Gram Panchayat has not executed it out of the fear from accused number one. When the officials went there 3 years back, they were threatened. They don't open the mouth. I was there because complainant was there. And he says, then also he says, who are the judges? What is High Court? I will show it to them.
Different part.
Yes,
Our shoulders are very broad.
yes, madam.
Yes.
I am obliged.
Yes, very broad. We
Yes.
will not bog down by such things, small things.
Please.
Here and there spoken, even if it is spoken. We are asking you, you are for the complainant.
Yes.
The direction in the order of the learned single judge against Tehsildar. Tehsildar is not a
I
party
shall.
in this contempt petition.
I shall.
Would you like to join? Or
I
you are
would,
doing
I
it?
would like to join him.
Learned advocate realizing the mistake that the Tehsildar against whom the direction is issued for removal of encroachment by learned single judge is not made party in the contempt proceedings. T6 paragraph. Permission of the court to implead Tehsildar so and so as party respondent. Permission is granted. The course title of the contempt petition shall be amended. Notice shall go to the newly added party returnable on 19th July.
Appearance of my, as appearance may be.
My lord, accused number one, my lord, my
Your
respectful
appearance.
submission, my lord. Having done all this, my lord, every time, not once, twice, thrice, 4 times. And when this honorable court, a judge of this honorable court in a division bench asked, again, he goes and says all this. My lord, it is the dignity of the court.
So pen drive was, what did your client?
My lord, he is trying to convert this civil
That
contempt
we-
to criminal contempt, my lord. My lord, he's produced some.
What utterances were made by your client?
My lord, my lord, he has already tendered apology. He has already tendered apology.
Where is that apology?
My lord, apology affidavit is filed on, my lord, 11/1/2024. My lord,
Where is the 11?
my lord, on 11/1/24, my lord.
There is no apology. We are trying to find out that apology, but we don't find.
My lord, this is the affidavit, my lord, filed.
11/1/24?
Yes, 11/1/24. And my lord, wherefore I most respectfully, honorable court, may kindly please to accept my unconditional apology.
Affidavit is filed.
Yes,
Affidavit is filed.
yes, this is fine.
So how this was, how this propped up, this aspect?
Because, my lord, what happened, my lord, in the earlier order, he himself, the respondent himself, kindly look at the order dated, my lord, 20/2/2024. My lord, he himself wanted to drop accused number 1 and 2. That was stated. Kindly note, my lord. Learned counsel for the complainant has filed a memo dated 21/2/23 for deletion.
Which date, order of which?
That is 20 February 2024. 20 February 2024.
February 24.
Yes.
No, it can't be because
Please. But
apologies of the.
this is the order, my lord. I'll read, my lord.
No, how
Learned,
these things cropped up about their utterances and.
Lord, occurrences, my lord, he says, my lord, he is, that is pertain to some other litigation, my lord, there are some other issues between the parties.
It is must be somewhere in the order. How all this started?
That is, nothing is in the order, nothing is forthcoming in the order. He has produced some pen drive. He is producing some pen drive before the court.
On your own you produced?
He is producing.
On his
And my
own.
lord, filing a memo,
On
not
his
even
own.
affidavit.
On his own.
My lord, of the pertinent.
My lord, he is not even filing an affidavit as required. He is filing a memo.
Pen
Yes,
drive was produced on his own or?
on, my lord. These are the memos.
My lord, when the
There is
Tahsildar.
that order recording about production of pen drive. How all these things started?
My lord, this is all started because of the order dated 21/2/2024.
And for the accused number 3 in this matter, madam, the complainant and the accused 1 and 2 are individual parties, and there's a grievance in the original order itself. They are rival gangs. Accused number 1 and 2.
We are not concerned. How this part of the
I'll just, not your honors may kindly take the order of this court dated 14/7/23. I'll just read the order of this court,
14/7/23.
14/7/23.
14/7/23. Let us. 14/7/23.
Just kindly, I'll just read out the order. Learned counsel for respondent number 3 would take the court through the sketch placed along with the objections and counter affidavit and will contend that there are.
You are
no
Mr. Ariga.
Yes, my lord. I am.
Learned Ariga for the complaint has filed a memo enclosing photographs to show.
Yes,
full stop. This matter took a different route.
Yeah.
When
the Tahsildar.
We are closing this.
Yes.
This part.
My lord.
We are not interested in continuing all these.
My lord, 1 second.
Plus things, Mr.
No. My lord, making.
We are accepting the apology, even if they had spoken something about the court and judges, we are accepting the
My
apology.
lord, making scurrilous attack on the High Court, on the Honorable High Court and the judges when the
They have
matter was
tendered the
pending.
apology.
Well,
They have said that they
No,
will not
no,
repeat
no.
anything.
Kindly permit me to read this, my lord. Kindly see just unconditional apology is a lip service. That is what, would your lordship kindly turn to page 58, my lord, of page 58, which is filed along with the objection. Annexure 4. When he filed this affidavit, the complainant placed before this honorable court the conduct of the accused on the earlier occasion, making such a petition and praying for the release. On unconditional apology he tendered. After unconditional apology was tendered and that was accepted, then he went on to do that. Thereafter, my lord, in this particular case, he has filed unconditional apology. That after the unconditional apology, he appears before this court. Again, after appearing before this court, he makes again a statement, scurrilous attack. That was brought to this honorable court. That is the reason why this honorable court proceeded to order that charges should be framed. Now kindly turn to page 58, annexure 4. A judgment of the Supreme Court. Judgment of the Supreme Court, my lord, page 58. My lord, counter affidavit dated 23/1/2024. Your lordship got it, my lord? Page annexure 4, page 58.
Where was the order about unconditional apology? You just showed us. Which dated? Unconditional.
My lord, 23/1.
17.
23. Yes, my lord. 23/1/2024.
23/1/20.
My lord, I'll read the relevant portion. Sri Srinivas submit.
23/1/24.
Yes, sir. Please.
23/1/24. That is it. No, yes. No, they have tendered and it is recorded that they tendered and continued.
My lord, here, my lord. My lord, I'll read the relevant portion. 23/1, my lord.
It is here.
Yes. My lord, Sri Srinivas, that is previous counsel, my lord, submits that he has filed an unconditional apology on behalf of the accused number 1. Sri Chandrakant Ariga has filed counter to the said apology. Same be kept on record. Yes, kept on record. That's order.
So
My
that
lord,
is all.
would your lordship kindly turn to page 7, my lord? The contempt petition.
Contempt is a,
Suo moto contempt, my lord.
contempt is a matter between the court and the contempt.
Yes, I am,
You don't have say beyond an extent.
I am trying to
We have heard
assist,
you.
my lord, my lord, I understand.
And this is not the matter where that part of the contempt should be continued and
no.
prolonged like.
No, my lord, kindly see for a minute to page 7. A suo moto contempt was initiated against the same person. What he did.
You take out the independent proceeding, not in this proceeding.
My lord, unless this is taken, my lord, I am nowhere. Because,
You can file independent proceedings
my lord, the independent proceedings for.
based on the pen drive and whatever it is said.
My lord, my lord, kindly permit
You
me
are
to read
abusing the
this.
process of
The-
law and the.
My lord, the accused was present in that case and again submit that they have no disrespect. Then heard in view of the unconditional apology, the accused are warned not to repeat such things in future. That was on 13/6/2009.
While the, write down, continue. While the Tehsildar, respondent 3 was not joined, he was the competent authority to comply with the direction, who now is joined as per the above order, these proceedings charted a different course.
My lord, if your lordship, my lord, permit,
Would you not permit us to dictate the order?
only to permit me to implead the Tahsildar, my lord.
It is already implemented. And notice is issued written on 19th. You are too engrossed in the other aspect of the
My
matter.
lord,
So you ignored that part of the order. It is already passed.
My lord, in that regard, may I also bring it to the notice of one
You are
judgment?
so engrossed in punishing the persons for contempt that you ignored the main part. That order is already passed 15 minutes back. Notice is issued, newly joined party is permitted. So
Yes, my lord.
are you proceeding, are you pressing this part or not pressing? If
Which
you are
part?
pressing, then we.
Which part, my lord?
This part, this very part, which you consider to be main.
Let the notice go to Tahsil.
About the contempt committed by 1 and 2, which you are now arguing.
My lord, I leave it to this honorable court because before my lords were to proceed, I am only bringing it to the notice of the court. Supreme Court has said that we are sorry to say we cannot subscribe to the slap
Write down
say
again,
sorry and
again.
forget.
While the respondent 3 Tehsildar was the authority who was directed to remove the encroachment, but not joined in the, but initially not joined in the present proceedings, and now joined as per above order, the present contempt petition charted a different course when learned advocate for the complainant on 14/9/23 produced some photographs showing the participation of private respondent 1 and 2 in a public meeting. Photos sought to be alleged and submitted that private respondent made some disparaging remarks against the court and the court proceedings. Full stop. Subsequently, it appears that some pen drive is produced. Full stop. On 3/1/24, learned advocate for the said respondent 1 and 2 submitted that the pen drive did not pertain to the present case. Full stop. It was recorded thus, and from 3/1/24 no order in his usual fairness, that paragraph to be reproduced. Full stop. Learned advocate for respondent 1 and 2 again reiterated on 11/1/24 that the footage of the pen drive did not pertain to the present case. However, he undertook in his all fairness that to state that he will file an affidavit expressing his regret and seeking unconditional apology during the course of the day. Full stop. The paragraph on 23/1/24, learned advocate filed unconditional apology on behalf of accused number 1 Response number 1, Sri Chandranath Pariga, which is taken on record. Full stop. The undertaking and the apology filed on affidavit by response number 1. Inter alia, reads as under, extracting the relevant parts from paragraph 6 of the undertaking. Pura 6. Full stop. The court does not show any good reason to continue the said controversy. The unconditional apology is expected. Full stop. The private respondent shall continue to express, continue to abide by the undertaking to hold the court and the court proceedings in high respect. Full stop. They said the aforesaid part of the proceeding is closed.
Yes.
Presence of respondent 1 and 2 are exempted in the further proceedings.
Yes.
My lord, it's only my humble request that when the dignity of this honorable court in openly derogated and scurrilous attacks are made on the judge and wide publicity is given, my lord, it is my
You
duty to.
instruct your client not to do this.
Please.
It is
Already,
my,
I have already done that.
If at all done, we are not examining.
it is
No,
my
they are-
duty, my lord. I thought that it should be brought to the notice of this honorable court. Ultimately, this court only can safeguard, and my lord expressed it, that the shoulders of the court is broad enough.
Yes.
Number 16, the complaints in contempt matter, the Sandeep Lahiri.
And for the accused, my lord. Already complained, my lord, in April 10th, we filed the complaints report.
Bill number
It
16.
is an interim order. Writ petition is pending, my lord. Only interim order, they have filed the contempt.
But Lord, the affidavit indicates, my lord, that they are they have committed a, my lord, they have violated the order. Lord, 10/4/2024, my lord, they have filed an affidavit. Page 3, my lord, indicates that although there was a direction not to alienate, they, my lord, executed 3 sale deeds in respect of 3 parcels of land, which they have tried to, my lord, undo now by issuing orders of cancellation. Page 3, my lord, of the compliance affidavit, my lord, which they filed. They identify, my lord, 3 properties. Paragraph 5 onwards.
Where is the compliance? Yes,
10.
paragraph 5.
Yes, para 5 at page, internal page 3. But they refer to the fact, my lord, that they have executed sale deeds in respect of these 3 properties. They say that it's a mistake that has occurred. When they received notice of contempt in the present proceedings, they realize that it's a mistake and they produce, my lord, annexure R1, R2 and R3, which are orders of cancellation of allotment. At page 9 onwards. It's in Kannada, my lord, 3 orders.
Where are the directions to be complied with?
No, that is at page 14 in the contempt petition,
Page 14.
1/4. Not to alienate. That is at page 1/4, my lord, order dated 11/9/2015.
What happened to the writ petition?
Lord, it's pending, Lord. Muda has not filed any objection. Their contention, Lord, in the writ petition is the acquisition has lapsed because they never took possession, nor did they deposit the money till the new act came into force on 1/4/2014. They have not taken possession. I am still in possession.
Lord, partial compliance.
But it is complied with or not?
Lord, while they have passed an order of cancellation of the allotment, now that they have made a statement, my Lord, that there are sale deeds which have been registered, Lord, possible, there is a direction in the cancellation order that the allottee should come, cancel the sale deed, and they will be given an alternate allotment. That process has not been completed because there is a, it will still show in the encumbrance, my Lord, that there is a registered document, and that cannot be cancelled without by way of any unregistered order or document. So they have to complete the process.
No, for allottee, they have communicated this orders, my lord. Cancellation order already they have received.
But there is a they have registered a sale deed.
Still, the complainant has to prove the case before the single judge. It is pending. This is second round of litigation, my lord.
That is
92 accusation they are challenging in second round. Already attained finality in Supreme Court in 2014 itself.
Lord, they admit the fact that there is a violation. Lord, they should purge the contempt completely and not just issue an order, Lord. The process has to be completed because they have not taken possession in terms of Lord, the old act.
The present commission is different, my lord. The compliance report filed by this, before filing the contempt, he relieved from this office. But the present commissioner got verified and passed the cancellation orders. But accusation notification have not been stayed by the single judge, my lord. Already project has been implemented.
May I? Lord, this land, my Lord, is my ancestral land. I got it under a partition in 1963. They were forming a ring road in Mysore, my Lord, for which this acquisition was contemplated. I said, my Lord, that I will give up 6 acres, 11 guntas of land free of cost without taking compensation, and you may take that and implement. That has been taken, and road construction is implemented. Muda passed a resolution. Mysore Development Authority, my Lord, passed a resolution to say, we are not interested in the remaining acquisition. That was sent to the government. Government, my Lord, after some time rejected, my Lord, it did not accept the resolution of Muda. Thereafter, my Lord, possibly because Muda was also not interested in the entire process, they neither took possession of the remaining area, nor did they deposit any money. And that has remained in that position, my Lord. 2015 March, they filed an LAC, land acquisition case, and tried to deposit the compensation only after the coming into force of the new act. But that is the list, my Lord, which is pending before the my Lord in the writ court. There is an interim order not to alienate. As a matter of fact, the affidavit, my Lord, now filed clearly indicates that they have violated the order and they have executed a sale deed. They want to undo that. They have passed an order cancelling the allotment. Lord, they have to complete the process by cancelling the registered sale deed and, my Lord, completely purging the contempt which they have committed. They also say, my Lord, that it was inadvertent error. They were not able to identify. Now they have undertaken the process and identified the land.
So anything?
No, please.
So you cancel the sale deed or not cancel?
No, cancel, my lord. No, no.
Very-
Orders in the order, my lord. Cancellation order is there. It specifically mentioned they have to surrender all originals to the authorities. Thereafter, they will give you the alternate site, my lord.
What do you say?
Sale deed has to be cancelled, my lord. All that I'm saying is, there is a registered sale deed that cannot be cancelled just by passing an order sitting in his office, my lord.
Well,
That,
my submission
that
is
has to be
un-
cancelled
un-
by a registered document. That
Madam, my
process
submission
let them
is-
complete. That's all I'm saying.
My submission is until quashing the entire acquisition proceedings notifications, he has no independent right to pursue the contempt proceedings. Now kindly see the page number 39, madam, para 3. Earlier proceedings till Supreme Court, it has been mentioned, my learned friend has mentioned in the petition. Now writ petition is pending. If they succeed and it attained finality, accordingly authorities will act according to the court direction, my lord. This is only interim order not to alienate. According to their verification, they found and in pursuance of the interim order, whatever the documents are, they would.
He admits he has alienated.
Once it is cancelled, my lord, ultimately authorities will do the registration cancel. It will be automatically, they will do
Let
it.
them
my
do it in some time bound
because
manner.
by receiving the original documents from the allottee, thereafter they will, my lord. In March only they will, they
So
will
for
issue.
orders on next Thursday. For orders on next Thursday.
My submission, my lord. If that is the case, my lord, direction may be issued, I can communicate to the authority.
What
In pursuant of the orders, cancellation orders, they have to complete the process of cancellation of sale deed also. It is categorically mentioned in the order, my lord.
You are willing to undertake the process of cancellation of sale deed also.
Naturally, my lord, because once it is authority is bound on duty, my
Very
lord.
good. You have taken note of. You are keeping for orders.
No, my submission is
He wants a
by
direction.
recording this compliance report, my lord, it can be disposed of. Because he is not, there is no, because interim order, only interim order, it's not the main
We
order.
are keeping for orders. We don't know what we will do. And have, why you are so.
Please. Please.
Next Thursday.
May I request, Lord, that his statement that they will undertake the cancellation may be recorded. I aid him, my lord, in taking. That's what he is
It is
possibly.
in order categorically mentioned, my lord. I will produce before the court. It is
You
there.
want some
It is in
order
Kannada.
so that they can further comply.
Please.
So what statement you are making? What statement? You will take further steps to
No,
cancel?
no,
the-
in pursuance of the cancellation order, after receiving the original documents by the
1 second. In pursuance of
cancellation order,
the cancellation orders.
Annexes R1 to R3.
annexure R1 to R3, my lord. Annexure R1 to R3.
Yes,
After receiving
yes.
original documents by the allottee, the authority will take steps to cancel the registered deed.
Which authority?
Please,
Which authority?
the accused, my lord, MUDA, Mysore Urban Development Authority.
Mysore Development.
Authority, my lord.
Mysore Urban Development Authority.
Yes.
They'll take necessary steps to cancel the.
Yes, already mentioned in the order, it is in Kannada, my lord.
Same thing we are going to do on
Please,
this Thursday, but
please.
today we'll do now.
Please.
Disclose. Will not, it is substantial compliance. And once the allotment are cancelled, automatically it means that the sale deed will have no efficacy.
Yes.
But now the council is very fair to make a statement also.
Let them do it in some time bound manner, my lord. Let him say in how many days he will do it.
This
Because
will
it shows in the encumbrance and the allottee may create some third party rights, my lord. That's my
Contempt is
difficulty.
taken care of, even if it all by this state. Disclose. Thank you very much.
Yes.
Hearing on interlocutory applications, CC number 17. To Chandrana, yes.
Accused number 6, my lord, your lordship's heard this matter on the last occasion.
What I appear for accused.
Mr.
A6.
Chandrana, yes.
A6 and 7 in this matter, my lords. I have filed the application
Which one? 17?
in serial number 17, my lords.
Yeah.
I have filed the application seeking a direction. My lords, but before that, my submission to your lordships is that nothing survives in this contempt.
Which affidavit you have filed?
My lords, I have filed IA number 1 of 23, where I've sought a direction, my lords. Your lordships may take my application.
So about payment of salary?
Salary, yes.
My lord, my
Where
lord,
is the-
before
where is-
that,
Where are the directions?
may I just point out to your lordships, my lords, this is a contempt regarding recovery of
Arrears
salary.
yes.
Please, my lords, according to the complainant, the amount was about 25.48 lakhs. By an order of this honorable court dated 24/2/2023, this honorable court has come to the conclusion that the amount is 7,24,104. The complainant has himself given up the claim for interest, and it's confined only to the basic salary now. My lords, pursuant to that, on 24/23, this honorable court directed me to deposit the amount in two DDs, one in the name of the complainant and the other in the name of the registrar. I've deposited those two DDs, my lords. In fact, the complainant was also given liberty to withdraw that amount. My lords, my humble submission is that with the deposit of the DD in favor of the complainant, my lords, nothing survives in this complaint. For the reason that according to my calculation, I have already deposited the said amount. If your lordships are kind enough to take my statement of objections, I have produced a calculation over there. Your lordships will be kind enough to take page 5.
You are paid something or not?
Pardon?
Yes. You are paid some amount?
I've paid the amount that this honorable court has crystallized. It started at 25 lakhs according to the claimant, according to the complainant. Thereafter, this honorable court said it's about 7,24,000, which I have already paid in the form of two DDs. According to me, the amount due is 3,71,687.
So give the calculation to the council. account.
So no, I'm for the state in this matter.
Very
We are a
good.
pro forma party. I'm appearing for the state in this matter. The claimant, the
Verify the
complainant.
calculation of the.
My lords, my immediate difficulty is this. The state has passed an order. This is an aided school. I sought to recruit teachers because there are no teachers. The state said on account of the pendency of this contempt application, they cannot give any permission to recruit teachers.
teachers.
Kindly see my IA, my lords. I've produced that endorsement.
The complainant appeared on the last date of hearing, said that he will come back before the court. And if he is permitted to withdraw the other amount of rupees 3,50,000, deposit to the registrar.
If your lordships are kind enough to take my application, I have produced a translation of the endorsement at page 10.
In the directions of the single judge, there is nothing what you are apprehending.
My lords, but however, the state has already taken that stance. Therefore, I'm before your lordships, my lords.
As well as the withdrawal and utility. 50,000 plus is deposited. It's a differential amount.
My lords, I've deposited one DD of 3,73,866 and one DD of 3,50,238. One is in the name of the complainant and one is in the name of the registrar. The one in the name of the complainant is equal to what is the undisputed amount. Beyond that, my lords, the claim of the complainant is 7,24,104. That's on merits, my lords. I'll show your lordships a calculation. Now my difficulty is what I've stated in my IA.
3,50,000 check is released in your favor, then things will be over.
Please, if your lordships may treat the compliance contempt as closed.
No, the complainant is not present. I am for the state in this matter.
Complaint is not.
She is the accused,
I'm
7
for
and
the
8.
accused.
The institution, the granted need accused, we are for the state.
So you have no objection to release 3,50,000.
My lords, 373,866, I have no objection. This honorable court has already directed me to
That
deposit
is
that.
directly in the
I've
name of
deposited
the
it.
complainant. That is directly in the name of the complainant.
Please.
So let the complainant remain present.
My lords, very well, my lords. I have another grievance which is against the state. Kindly take my IA, my lords. I have filed an IA.
IA in contempt?
It's not maintainable in this
What is
country.
that?
Please, my lord.
They're seeking
the
a
lordships may
direction.
kindly have it. I'll point it out. I'm an aided school. I sought for permission to recruit teachers. The state issues an endorsement that so long as this contempt is pending, they will not grant permission.
So wait, we'll dispose of the content itself.
Yes, sir.
Very well, my lords. Your lordships may record that the amount of 373,866, which is in the name of the complainant, which the complainant had already given
Complainant is
liberty
appearing
to
in
withdraw.
14%, as 14%.
No, they're represented by an
counsel.
advocate.
So who is the advocate? List it.
He appeared on last date of hearing, Your Lordship. One is
Learned,
Chandra Nair.
Learned additional government advocate Mr. Jaffer, as well as learned advocate Ms.
Nayantara BG.
Nayantara Nagaratna.
For accused 6 and 7.
That the remaining amount of 3,50,238, which is deposited in the name of register of this court.
Yes.
Would be released in favor of the complainant.
In, my lords, in my favor, my lords. My lords, if your lordships are treating the compliance, then the balance amount has to be given to me. My lords, according to me, the amount due I have already deposited, 373,866. The balance, my lords, is a disputed amount.
The complainant claims 7 lakhs of.
My lords, that is what I'm pointing out to your lordships, my lords, that in my counter produce a calculation that is not the correct amount. Kindly take my counter, my
And
lords.
without recording anything, we let us wait for complainant.
Complainant, yes, sir. Because it was adjourned with the direction that the learned counsel would seek instructions from their client, whether they will give this amount also to the complainant.
The calculation dispute persists, will permit you to proceed with the recruit on the next day.
On next day.
My lords, my only difficulty is now against the state. They have issued
that
an
on the next date of
endorsement that
hearing.
I'm not able to recruit teachers.
So we'll
That is what,
permit on the next day.
next date of hearing.
Very well.
Even if this dispute persists.
In fact, there's an interim order in my
It is
favor.
difficult for us in clarifying.
contempt petition.
The contempt jurisdiction.
My lords, the only reason why I'm pressing it in
But
the
we'll ask
contempt,
them and take their
Yes.
concession and then accordingly.
there is an order against the state not to take coercive action against me. I have an interim order in my favor. Even then, this endorsement has been passed, citing the pendency of this contempt.
Technically, you should file a small independent petition and seek the clarification from learned.
Yes.
My lords, this
relieve from this-
endorsement has been issued during the pendency of this, my lords.
We'll find out somewhere.
Wait.
Let us see. On 24th of June.
My lord, since I've already deposited the DDs, the state may take cognizance of that and grant me the permission to recruit teachers. That has got nothing
That
to
we'll do
do.
on the next day.
Very
Let
well.
us, in his presence of the councils of all the councils.
Obliged.
My lord, the interim order may kindly be extended.
Yes, 24th.
Your lordships may kindly extend the interim order,
Interim order already. What is the interim order?
not to take coercive action against the state. The interim order is against the state.
In contempt order, how can?
My lords,
interim-
that is because the single judge had given a direction to cancel my recognition if I don't make the payment. So therefore,
We are-
they
we are
filed a
implementing the order
contempt
of the
that I have
Lord
not
Single
made the payment, and the state took action to cancel my
Order
recognition.
oblique observation already granted in this proceeding shall have continue to operate till the next.
I'm deeply grateful.
Number 18. Shruti C.
But there is a challenge to the constitutional validity of section 40 of the
Seek a short
Biodiversity Act.
accommodation in the matter, my lord. What has happened is the petitioner in this case is Environment Support Group. And Mr. Leo F. Saldana who is the founder trustee of Environment Support Group, was appearing as party in person. He is recovering from a stroke, my lord. The matter has been remanded from the Honorable Supreme Court. If I'm granted a short accommodation, I'll assist the court in the matter in the next date of hearing.
But there is no difficulty, my lord. This matter will have to be heard because there is a challenge to the constitutional validity. But my lord, I have a request to make. My lord,
The constitutional validity of what?
of section 40 of the Biodiversity Act.
By
Biodiversity Act, on the ground that there is uncanalized power which is granted to the central government. But my lord, today it is listed for hearing on IA. My lord, I have filed an application. My lord, please have a look at the cost title at page 15. My lord, respondent number 2 is the relevant ministry, Ministry of Environment and Forest. My lord, please have a look at respondent number 5. My lord, unnecessarily the cabinet secretary is drawn in, my lord.
My lord, I'm
May I
giving,
request that, my lord, the petitioner may replace the cabinet secretary with the secretary of Ministry of Environment and Forest.
may I just make one submission, my lord? I'm given to understand that a similar application was filed on an earlier occasion.
Lord, cabinet, under Article 77(3), my lord,
My lord, I may just
The-
seek complete instructions in the matter and then we can.
no, my
can
lord, this,
take
my
them.
lord, the cabinet secretary has no role to play, my lord.
A similar
The
application. was
secretary,
already-
Ministry of Environment and Forest may be added. He is already there.
But what hurts you if he's a party?
I'm sorry, my lord.
What is the difficulty remains is?
No, difficulty means, my lord, a cabinet notice will go, he will have to file objections, then, my lord, if there is, it will unnecessary, my lord, involvement of the cabinet secretary. My lord, the role of the cabinet secretary is entirely different.
Don't
Lord,
file,
under-
don't file any response, don't respond.
My lord, then, my lord, it may lead to issues later. My lord, under Article 77(3) of the
Permitted to seek
Constitution,
complete instructions.
my lord, we have power to, the president has got the power to make rules. Their allocation of business rules are made. Under that, my lord, respondent 2 is the relevant ministry.
My lord, I'm given to understand that a similar application was made on an earlier occasion. I'm not aware of what order was passed. I
No
may
such
just be
order
permitted to
passed.
complete, secure
By
complete
learned
instructions in the
advocate,
matter.
Mr. This, what is the good name?
Shruti Chaganti, my lord.
Learned advocate for the petitioner, raised for time. From learned additional solicitor general, Mr. Arvind Kamath submitted that the subject matter of this petition should be properly responded to by respondent 2. Rest 2, na?
Two. Ministry of Environment.
and Forest through its secretary. He therefore submitted that respondent 5, which is the Union of India, arraigned AWIGND through its cabinet secretary. He is not a necessary party. Full stop. Keeping said respondent 5 as a party will burden the record. Full stop. In that view, submission is accepted. Why you can?
My lord, my only submission is I don't have complete instructions because I'm not sure what preceded
No,
the.
my lord, there is
at-
no
at
difficulty
array
with
of
the
parties.
relief.
The matter has
We
been
will
remanded
argue
from
on
the
it, my lord.
Honorable
We have
Supreme
filed
Court.
objections.
My lord, the matter has been sent back by the Honorable Supreme Court.
and they have to speak. Why don't you amend this number 5?
I'm just seeking a short accommodation, my lord. On the next date, I'll make submissions. I just have no instructions.
At the request of Learned Review, so and so, so and so, send over to 25th of June. On that day, you at least
Yes, ma'am.
apply mind to this aspect.
I will.
It appears to be reasonable.
I will.
So 19 urgent, seal number 20.
20.
Sidharth Nayak.
The petitioner has filed this PIL challenging the amendment which is brought about to Rule 8A, which is namely 8A1 of the Karnataka Minor Mineral Concession Rules, Your Lordship. As per this amendment, which is in contravention to the central government rules, where granite being a specified minor mineral, the maximum period of lease that can be granted for it can be only granted is only for a period of 30 years. As per this amendment, they've increased it to 50 years, Your Lordship. The Granite Conservation and Development Rules of 1999. Your Lordship, may I take Your Lordship's attention to
May make a submission.
So subject of mineral is in which list, concurrent list or both?
The challenge is to the amendment by the state government dated 17/3/2023, by which, my lord, the period of lease has been extended from 20 years to 30 years. Earlier, it was 20 years as in case of non-specified minerals. In case of specified minerals, it was 30. Now, by the virtue of this amendment, the period has been expanded from 20 to 30 from the date of initial lease. And in case of non-specified mineral, it has been extended to 50 years. That is in challenge now, Lord. My submission is, Lord, in this matter, AAG Jacob has been instructed, Lord. He wants some time.
Who is it?
Advocate General, Additional Advocate General, Mr. Jacob has been instructed to appear in this
Your
matter.
Lordship, the state government, they have taken time on several occasions, Your Lordship.
We have filed a
This
statement
petition
of
was filed in June 2023, Your Lordship. Since then, they are working double shift. That is what I have heard. The mining activity has increased. They are, Your Lordship, only by way of auction can the new lease be granted. But here, in order to favor the mining mafia, and this is also causing loss to the state exchequer to the tune of thousands of crores, Your Lordship, because auction is not conducted. They're illegally, auction has to be conducted. No, Your Lordship, they're illegally increasing it to 50 years. Yes. For the same royalty, same dead rent, which was there 30 years back.
There is also a provision that the mining should be given only by, lease should be given only by auction.
Only by auctions, section 10A, Your Lordship, of the MMDR Act. That it has to be only through auction.
Subject of mining is falling in which list? State list or concurrent?
Mining.
Concurrent list.
Mining is in the.
So what is your main submission?
Your Lordship, under section 15, they have carried out this amendment, Your Lordship. Under section 15 of the MMDR Act, this state amendment has been carried out. But under section 15, they are not given any powers to extend the period of lease. No powers are given. Even then, they have extended the lease, Your Lordship.
List 1, my lord. List 1, mining is in list.
Pleadings are complete? Pleadings are complete?
Pleadings are complete. We have filed statements.
I have not received a copy. None of copies.
Respondent number 4 also has filed a statement of objections.
Your Lordship, I have not received copy from the state government.
You.
Even the Union of India is made a party, Your Lordship.
We'll file. Pleadings in the matter shall be completed within 2 weeks. To be listed on, within 3 weeks, to be listed on 3rd July.
3rd July. Your Lordship may kindly grant an order of stay, since I've already made out a case, Your Lordship. It is in violation of the GCDR rules of 1999 Granite being a specified minor mineral, the maximum period of lease is only 30 years. Now they've made it 50 years, Your Lordship.
Madam, who said that you made out a case? We'll hear.
I'll point out the relevant provisions now itself, Your Lordship. It is in violation, gross violation of the central government rules.
We will consider on third. So we are fixing, directing to complete the pleading.
Please.
So on third, we'll really proceed is important subject, important matter. Because extending the lease for 50 years on the face of it until you justify and unless you justify.
Obliged. Your Lordship.
The legislation can be challenged on the ground of breach of Article 14 also. Now, recent trend is that this might turn upon that aspect also.
Number 21, Mr. Abhimanyu Arjun.
Filing a memo, my lord, withdrawal with liberty to approach the state government under, my lord, section 29 of the Water Act, which is a, my lord, revisional provision.
When the present writ petition comes up for consideration, learned senior advocate Mr. Uday Holla with learned advocate Mr. So-and-so files memo dated 5/6/24. Of the memo reads as the contents of the memo reads as under then for the entire petitioners are permitted to withdraw the in the above light the petitioners are permitted to withdraw the present petition and approach the competent authority under section 29 of the Water Act 1974 with appropriate appeal application which shall be considered in accordance
State government, they're not a party here, if they want to go elsewhere, they can.
wherever they want.
Liberty to approach, my lord.
Liberty is reserved to approach as above.
Also ask
The
for a
petition is
extension of
disposed of
stay.
without going into the merits of
Ask
the
for
case of
interim
the
order
act.
Lord, interim order is already there. It can be extended till, my lord, the government considers it. my
So
lord.
at this stage, learned senior will be requested that the interim order is operating in the matter. And if it is not extended, come on the recourse to the competent authority under the Air Act.
Water Act.
Water Act.
Would create irreversible situation. He therefore requested to extend the request is not unreasonable. Full stop. The interim leave it is already granted by this court and has operated till date shall continue to operate for a period of further 4 weeks, within which time the
Disposal.
2 weeks.
Till the disposal also, my lord, and
The
your lordship can
disposal.
direct the government to dispose of within a particular period also. Your lordship can also direct the government.
Government is not party.
It's not a party until the disposal of that application. We do not know because they're not parties here.
But 2 weeks within which time the application of the couple shall be filed. That's all.
4 weeks, my lord.
4
Because
weeks.
they'll have to,
4 weeks.
government moves, my lord, very slowly. Grateful.
No, this will continue for 4.
Yes, no. Yes, that's all I
Cannot directing to complete the.
No, my lord. No. I agree. Sorry.
So
I
why not,
misunderstood.
why not 2 weeks? Within 2, so that you can approach without any delay.
Please, my lord, please.
That is the idea.
Grateful, no. I'm sorry. I heard it as, my lord, 2 weeks.
So if the such appeal applicable is filed, the competent authority shall dispose it of as expeditiously as possible.
Please, grateful.
This court has not gone into the merits of the case.
Please.
It will be open for the petitioner to seek extension of the interim leave to be considered by the authority in accordance with law. Extension of the interview during the pendency of the appeal oblique application, which shall be considered by the authority in accordance with law and on its own merits.
Lord, I must appreciate, my Lord, your Lordship concern. Without my asking also, your Lordships are, my Lord, saying this. Lord, we all appreciate.
So
my
that
Lord.
things are balanced.
Grateful, my Lord.
Non-filing in contempt matter, still number 22, Mr. Subramanian Bhattacharya.
For the accused.
For the
The
complainant.
order of suspension was set aside, but she was ready to reinstate the complainant. Prays for 2 weeks time, your lordship. The difficulty was the body of the Gram Panchayat has passed an order of suspension. To reinstate him, my lordship, there was a code of conduct, my lordship, till yesterday. Within 2 weeks, my lordship, we will comply the orders of the son.
Counsel for the respondent, prays for time, stand over to 2nd July.
Please.
Great, great.
Number 23.
My Lord, I
Chandranath
appear for
Argole.
the appellant in the appeal, my Lord. My Lord, I pray for
For the
2 weeks'
complainant, my
time to comply with the office objections, my Lord.
That is again payment of some salary.
Yes, my Lord.
Salary from 2012 till date.
Yes.
Please.
Against which we have filed an appeal. My Lord,
File appeal.
yes, my Lord, 23.1, I have filed the appeal. Pray for 2 weeks' time, my Lord, to comply with the office objection.
Petitioner worked or not? You work?
Sorry, my lords.
You work, discharge your duties as teacher.
A fitter, my lord, trainer, as a trainer.
Trainer. You discharge your duties or not?
No, no, my lords.
No.
No, my Lord, he did discharge.
I'm sorry, I did discharge the duty, my lords.
But then it is said that your stand is that his post was not.
Admitted to grant. My Lord, I'll convince my Lord, my Lord.
On the ground
There are-
of, if you worked as a trainer, you are entitled to salary. Simple.
My Lord, I'll argue and leave it. my
Without
Lord.
going into anything. Anyway.
2 weeks, my Lord.
2 weeks will grant.
Copy may be handled.
I'll fund.
2nd July.
Obliged, my Lord.
Time to comply with the office objections in the writ appeal is granted up to 2nd July. The appeal along with the contempt petition shall be listed on 3rd July.
Obliged, my Lord.
Number 24. Shubhabar Mishra.
Hearing for the complainant,
Yes.
I have one small
Okay.
submission to be made. On furnishing, be permitted to furnish the memo of calculation. This is with regards to the amount of permanent alimony that is to be paid, because the order specifically states, if my lordships may kindly peruse the final order, it also says there is an interest that has accrued. So
Pardon?
there is an interest, my lords may kindly peruse Annexure A, page number 16. Final order.
$18 lakhs.
Page 16, my lord.
Hmm.
The respondent / husband shall pay rupees 75 lakhs towards permanent alimony of his wife / appellant and 2 children, Anchita and Abhigna, within 3 months from this date.
With interest.
Failing which the amount shall carry interest. So my lordships may kindly permit me to furnish the memo of calculation stating how much
Today
is
you're
the final
paying
amount.
We are paying 30 lakhs, my lord.
My lord,
Is prolonging. The one, the RP also is pending still. She is working also, is not considered the order. We are appealed to this SLP.
In light of the order dated 29/5/24 passed by the court, according the statement of learned respondent, today when the contempt petition comes up, learned respondent stated that he has brought the check amounting check for rupees 30 lakhs to be handed over to the counsel for the complainant wife, full stop, the check bearing so and so, so and so, bearing number 9489481177 dated 23/5/2024 drawn on the Kotak Mahindra Bank is handed over to learned counsel for the complaint to be handed over to the complainants towards alimony in compliance of the order brought under contempt. Full stop. Put up, full stop. At this stage, learned advocate for the complainant submitted that she may be permitted to file the statement of calculation of the amount payable by the respondent. Full stop. The same shall be filed to be given the copy thereof to learned counsel for the respondent as well. Full stop. Put up after 7, put up after 8 weeks. It is a, are you really after interest?
Please, my lord,
Don't-
if I may make a submission, my
We'll
lord.
see after it.
That's number 25, Mr. G.R. Mohan.
Lordship, this matter, this court was pleased to pass order on 3rd April.
My lord, side.
3rd April order, Your Lordship. 3rd April, wherein the earlier 72 acres of in which water body was there, Malatali Lake. Then after when the interim order was passed, direction was given by this court, it reduced to 44 acres. Now, as per the record and notice issued to BBMPA, now it is hardly 3 acres of water body storage area is left. Everything is encroached, constructions are taking place. So that's why Your Lordship on 3rd April specifically order us, no further time can be granted. However, as a last chance, 22/4 it can be 3rd April.
So what is not compliant?
They are not complied.
My lords, I'm seeking for a short accommodation to file my response, my lords. The officers were deployed for the election duty and the
You
election
are
is.
for whom?
My lords, I appear for the accused, my lords.
This order in IA,
Yes.
or like file it, 4 weeks.
And actually D is the direction. Your Lordship. And in fact, today is the World Environment Day. Basically, we have to preserve the water body.
July, somewhere in July. 12th July.
Please.
Number 26, Mr. Nataraj Ballad.
I appear for the
Lord, an interim order was granted.
7th accused.
Interim order was granted, my lord, staying the blacklisting of the complainant. And he had filed his tenders, my lord, before the accused numbers 1 to 6, who despite having knowledge of the interim order, my lord, proceed to reject the tenders on the ground that, my lord, a legal opinion is sought from the advocate of the respondent authority, and they reject the tenders, my lord.
May I make one submission? May I make one submission? Your Lordship may kindly turn.
We are not entertained. Interim order.
My lord, in the final order, my lord, liberty was granted. Your lordships may kindly see the order passed by the tendering authority, my lord, rejecting my tenders, saying that, my lord, an opinion was sought by the advocate.
Out of remedy of damages, whatever, or before learn a single judge, independent remedy.
Lord,
Lord,
the
that
final order is passed. Your Lordship will get final order at
Yes.
page 89, Annexure H. In that, my lord, the impugned communication of blacklisting is withdrawn by the accused persons.
it is not that.
Where is that?
Please, my lord, in page 5, my lord, at
Page 5.
80, I'm sorry, my lord, 83 pagination is
No,
not
final
proper.
disposal, the
Annexure
writ
H.
petition is finally disposed of, my lord, but liberty was reserved to me to avail the remedy under law, my lord. When there is an interim order in my favor, my lord, 9 tenders were rejected on the ground that, my lord, saying that opinion was sought by from the authorities, from the advocate, who says that it could be
Page 89, my lord. Annexure H. The final
Lord,
order
in
is.
that event, my lord, the interim order in my favor, my lord, will have no bearing at all, my lord, if the authorities have the liberty to reject my tender. despite noting it that, my lord, there is an interim order in my favor.
Para 8, my lord. Or learned advocate, Mr. So
My lord, my lord, may I proceed, your lordships? Kindly see page 34, my lord, the tendering committee's order rejecting my tenders.
You can have a remedy other than contempt. Not for damages.
Lord, with that liberty,
Lord,
my lord,
even then,
if
my
that
lord.
liberty is granted, my lord, my client would have to only pursue that, my lord. Otherwise, my lord, the
Liberty
interim
is-
order granted in my favor
Liberty
and
is
thereafterwards.
Already granted by learned single judge. We can reiterate.
No, that liberty is one for, according to me, my lord, that is only for contempt, my lord, for the reason that. Now, the reason is this, my lord, 9 tenders I have been rejected despite the interim order in my favor. And the authority says that, my lord, by the legal opinion, they can reject my tenders. If that is the case, my lord, then interim orders are of no consequence at all.
My Lord,
in my favor.
may make one submission, my lord. If your lordship may kindly turn to page 7, accused number 7, Union of India. My lord, no orders of this court is violated by Union of India, so I should be deleted at the first instance.
Excuse, my lord, the government
But
is
let
made
me-
a party.
Sir, let me complete.
Please,
Let
please.
me complete. Union of India is arrayed as accused number 7.
No, no, I'm sorry, my lord, it could not have been accused number 7, it could have been only respondent, my lord, because
Lord, I
the
am not
office
a-
raises an
Sir,
objection
sir,
saying
one
that.
minute, sir, 1 minute, sir. Let me complete, sir. If your lordship may kindly turn to the order, final order. My lord, Union of India was neither a party.
So who says that you are going to fasten with any liability at this? We are only reserving some liberty.
Please.
If at all available.
My lord, may I submit on that, my lord, because the reason is this, office raises an objection. There is a direction that Union of India or the state government has to be made a party.
Original set of parties. Heard learned advocate, Mr. So and so, for the complainant, and learned additional advocate general, Mr.
Lord, Deputy Solicitor General.
And learned
Respond number one, accused number 1 to 6, my lord.
so and so, 1 to 6.
1 to 6.
You are for.
Lord, I'm been arrayed as a Union of India,
I'm
not
sorry,
by
my lord, I'll
name,
correct it because it should
not
have
by
been
name
respondent
of
number
the
7.
any accused person, not by name of the accused person.
Respondent number
7, respondent number 7.
learned additional 7 and so and so for number 1 to 6. The contempt jurisdiction of this court under the contempt of court act 1971 is invoked by the complainant original petitioner in respect of order dated 9th June 2022, passed by learned single judge. Admittedly, the order brought under the contempt jurisdiction is an interim order whereby only notice was received in the petition and stay of communication dated 2/6/2022 was granted pending the petition. Thereby the order of blacklisting against the petitioner came to stay. Full stop. The main writ petition number 11, paragraph 11/250 of 22 came to be finally disposed of on 20th February 2024. The given communication dated 2/6/22 was withdrawn by the competent authority, which was recorded by learned single judge, and it was therefore recorded that no indulgence was necessary. full stop. Learn a single judge in the final order, reserved liberty to the petitioner to avail such remedy as may be available in law in the event of need, petition stands disposed of, and petition was disposed of. This court is not inclined to exercise its contempt jurisdiction for two main reasons. Firstly, the order when brought under contempt jurisdiction was interim order, and final rights of the parties were never crystallized. Full stop. The subject matter challenge. Secondly, subject matter challenge. Subject matter of challenge in the writ petition was withdrawn, which was impugned communication dated 2/6/22. Full stop. No case is made out to exercise the contempt jurisdiction. Full stop. Learned advocate for the complainant, however, submit that despite stay granted as per the order dated 9/6/22, the authorities rejected the tenders of the petitioner. Full stop. For this, it is observed that on this court, the petitioner may avail independent recourse, independent remedy, taking such records in accordance with law, as per the liberty already reserved by learned single judge, which is also reserved by this court. About any such recourse, however, this court does not express any opinion on the merits. The contempt petition is disposed of accordingly. Great. Now it was not disposed. Council Nothing requires to be done.
In his presence only, my lord, it was conducted.
No, I do not know because I don't have the copy of that annexure.
No,
If
no.
my learned friend man have it on any other day, my lord, we will.
I shall give it to him.
It is in your favor.
Please, my lord, I'll have a look at it because I have not seen that.
In his presence only, this joint inspection was conducted. He has attested his signature.
Mahajar report. Mahajar report used by learned government advocate along with the statement of objection. Inter alia records finding that there is no violation of any provision of Karnataka Regulation of Stone Crushers Act 2011. In other words, the report stands in favor of the complainant. The report was prepared in the presence of complainant, crusher of the owner, and the photographs were taken in his presence. So the report was read over in presence of the officers. To be listed on, looking to the scope surviving in the petition, to be listed on 11th at 2:30. 11th June at 2:30. In the meantime, copy of the information report shall be made. Given.
He has given it to me, ma'am.
Then what remains?
No, I want to see. I will have a look at it because I didn't know about it till now. He's just given it to me now.
Well,
Please.
Sir Satish?
ಸರ್ ಹೇಳಿ ಸರ್.
ಸರ್ 230 ಮೀಟರ್ ತುಂಬಾ ತಗೊಳತ್ತ ಅಥವಾ ಕೊಲಾಪ್ಸ್ ಆಗುತ್ತಾ ಸರ್?
ಬಂದ್ಮೇಲೆ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್, ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಪರ್ಮಿಷನ್.
ಯಾಕೆ ನಂದು ಸಿಲಿಂಡರ್ 62 ಇದೆ, ಚಾನ್ಸ್ ಇದೆ ಏನು ಅಂತ ಅಷ್ಟೇ.
ಎರಡು 230 ಇದೆ, ಎರಡು ಪಾಸ್ ಓವರ್ ಇದೆ ಸರ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂಯೇಷನ್.
ಓಕೆ ಸರಿ, ಹಾಗಾದ್ರೆ 3 ಗಂಟೆಗೆ ಎಂಟರ್ ಆಗ್ತಾನೆ ಹಾಗಾದ್ರೆ.
ಹಾ ನೋಡಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ರೈಟ್ ಸರ್.
ಎರಡು 230 ಇದೆಯಂತೆ, ಎರಡು ಪಾಸ್ ಓವರ್ ಇದೆಯಂತೆ.
31.
Yes, 31.
Short time.
Withdrawal.
Adjournment. Mera, adjournment.
Which date do you want?
Whatever, next week.
July. 8 July.
Much of
Seal number 11.
My apologies, my lord, I was held up in the morning in another. My lord, the BBMP is before your lordships. The issue arises like this, my lord. We engage employees on contract basis, and the obligation to pay provident fund is on the contractor. Our agreement with the contractors will not provide that the contractor shall register all the employees, pay the minimum wages, comply with all the requirements, and also pay provident fund. And they must give us the details. Now, my lord, what happened in this case was an inquiry was instituted, a complaint was filed by the workmen that all the Paura Karmikas who are working through these contractors, they don't have details of their employment status, their PF cards, etc. The inquiry, my lord, an inquiry committee went into it, and in that committee, my lord, some information was given by us also, and that committee submitted a report to the PF authority, who, my lord, passed an order initially, and that order, my lord, BBMP wanted to, my lord, question it, so they filed a review, and that review was also, my lord, declined. Parallelly, my lord, the authority proceeded further to make an inquiry to determine what is the sum due and to whom it is due. In those proceedings, my lord, also I must confess, my lord, that the BBMP has miserably failed in producing the data and the material that was available with it before the authority to show that all employees of the contractors have been covered. Now, my lord, the learned judge, my lord, then proceeded to adjudicate the matter and notices that the earlier order has not been challenged. Therefore, there's nothing much to do now, and confirmed the demand of 90 crores of rupees and directed that we should pay the amount to the PF authorities. We filed the appeal, my lord, during the pendency of the appeal. That money, my lord, has now been attached initially, now recovered. The bank has issued a DD for 90 crores in their name, which I'm told, my lord, has also been encashed today. Lord, my only submission is this, my lord. The fact remains, and there is documentary evidence. I'm a statutory body. I'm not some fly-by-night operator or somebody. I got entire records. I have not filed an application for additional documents, which I should have filed before the learned judge, which I didn't do. I didn't file it before the learned judge also. If I had filed it, the case would have taken a different complexion. But now, my lord, this is my predicament, my lord. There is an order passed. If your lordships would see the impugned order in the writ appeal, that is the order, my lord, of the authority. Page 100. Page 47. Starts at 47. This is the order which was challenged before the learned single judge. At 48, second para, as the establishment did not comply with the statutory provision, an inquiry under 7A of the Act was initiated for assessment of dues payable by the establishment. Summons so and so dated 10/9/12 was issued to the employer to appear before the 7A authority and present the case. Inquiry was held on various dates and concluded on 14/9/17. Starting from September 12, about 69 hearings have been provided to the establishment to present their case. Then, my lord, next 2-3 paragraphs, they say who has become liable, etc. And please, my lord, go to page 49. The inspecting teams, my lord, the submissions that they made, last para in page 49. The inquiry under 7A was initiated on 10/9/12 for assessment of dues from January 11 onwards. Inquiries are conducted at regular intervals. As BBMP failed to produce record, squads were formed to inspect and collect records from different zones of BBMP. In the meanwhile, the workers' union also lodged a complaint which was taken on record. BBMP is a statutory body having systematic organization with officials and officers with vast powers. All functions and all the transactions are properly recorded with all details and are subject to audit. As such, there should not have been difficulty to BBMP in furnishing the details of works undertaken, contracts awarded, employees engaged, but the same were not being furnished as required and requested by the department. As BBMP has furnished only partial records, an order may be passed based on the reports, records submitted, amendments made during the course of the inquiry. So according to this, there were some records that we produced, and what those records showed will have to be examined by the authority concerned. Then, my lord, next 3 or 4 paragraphs, my lord, are not relevant because that's the legal position. We are not disputing the legal position that contractor is liable to pay, and I am required to collect and pay through the contractor. Then, my lord, page 53, the stand that we take before the officer, middle of page 53, the establishment has submitted partial records to various inspecting teams and enforcement officers based on which the report is compiled and the copy of which is handed out to representatives of BBMP on 23/8/17 for filing their replies. Nothing has been submitted in writing by the BBMP. However, during inquiry on 14/9/17, the representative stated that the work orders are issued to family members of Porokarmikas. In the case of death resignation on need basis, it is stated that piecemeal temporary work orders are issued. Sri Shakti Sangha, Women's Group, NGO Self-Help, also issued with temporary work orders. The authorized representative so-and-so has stated that the entire report has been studied and confirmed that no social security benefits have been extended to temporary workers called equal work, equal pay workers and accepted to render compliance and regularize as per law. So this is a stand that we take. Now the authority, my lord, should apply his mind to what is before them. Please then go to, my lord, next page. There's a reference to section 8A, and there are case laws that are referred, my lord, the note not in dispute. At page 54, bottom, my lord, para 5, employees engaged through contractors. All these categories of employees are not identifiable. The matter will be taken later. These categories of contractors are seen awarded work orders for multifarious activities of BBMP, wherein employees are not identifiable. As far as the enrollment of employees engaged in these categories of contractors is concerned, the EO has quantified the dues based on the contract amount, applying the principle of averages. Though it looks rational, the possibility of huge variation, either side, that is higher or lower, cannot be ruled out. It is preferable to take up this issue separately by a separate section 7A exclusively for assessment of dues in respect of this type of contractors, so that a proper assessment can be made in respect of readily identified employees in these proceedings. This is the finding now of the authority. Next para, my lord, conclusion is reached. Now, therefore, I so-and-so in exercise of powers, having regard to the facts, considering submissions, evidence on record produced before me, hereby determine 90 crores, etc. on account of Provident Fund, Pension Fund, Insurance Fund, contributions, administrative charges for the period January 11 to July 17 in accordance with the provisions of the Act. Now, what is this 90 crores? What is the basis for its determination? From whom it is due? And
You are able to
I
dispute.
appear for the Provident Fund.
You are not disputing your liability.
My lord, my submission is only this. I have engaged contractors. Contractors are engaging workers. The contractors have enumerated all the workers under them. They have paid Provident Fund. And my lord, if your lordship would permit me to point out, I have filed additional documents which contains all the information. Now, my lord, if the Provident Fund, this is a authority, Provident Fund authority, my lord, is acting on behalf of the workmen. Now, all this information is available with them. Now, I agree, my lord, the other side, the main point they're urging is this issue was raised earlier. There was an order. I challenged it in review. I didn't further challenge it. I accept all those things. No, it's an institutional failure. That's all I can say, my lord. If a public institution like this, my lord, conducts itself in this manner and doesn't place material that is available with it before the authority, and the authority passes an order, before the learned single judge, my lord, the same thing happened. This order was challenged, Lord. When pursuant to this order, an attempt was made to attach my bank account. At that stage, they filed a writ petition challenging only those proceedings. So the learned judge dismissed my writ petition to say you're not challenging the main proceeding. What is there to examine? The report that was submitted, my lord, by the investigating authority to the commissioner, that is also not part of the record. I don't have it.
Some order is operating in your favor.
Now, my lord, what has happened is, my lord, because of this order now, they have enforced recovery and recovered 90 crores rupees from my account.
Already recovered.
Already recovered. Today morning, they have encashed the DD, my lord, which the bank has given. First, they attached it. And my lord, yesterday when matter was adjourned, my lord, they have today encashed that money and it is with them. I'm a public authority, my lord. I have a lot of civic duties to perform. It's not that I'm going to run away somewhere. And this is not a money which has to be disbursed immediately by them. I can understand, my lord, in some case, there is some disbursement to be made by them. That is not so. Lord, my request is I need your lordships to consider giving me one opportunity, my lord, to go back before the learned single judge. Because I didn't file my counter. If your lordships could just peruse, my lord, the additional documents that I have placed before your lordships. It gives complete details of all the contractors. Not I have filed with permission, my lord, and affidavit with the documents, which contains every complete detail. Who are my contractors? Who are their employees? What is their PF number? This information which I have given to your lordships relates to only one division. I didn't want to, my lord, burden the court's record with all the divisions. This is a complete failure, my lord, on the part of BBMP in defending itself, in placing material before the authority. I, in fact, my lord, inquired what action have you taken against the officers who are responsible for this. The answer I got, my lord, was that most of the officers who are involved in this, they are all on deputation. Their deputation has ended. They have gone back to parent department. So we can't even take action against them.
My lord, in this I appear for the respondent number 1, my lord. I was the petitioner in the writ petition. I represent the union, my lord. In fact, my lord, the order that was read out, 26/10/2017, what senior counsel just read out, that order, my lord, has not been challenged anywhere.
But probably law, Mr. Naganan, is against you.
The law, my lord, is that I am required, my lord, first of all, the PF.
The employees of the contractor functioning under the Contract Labor Regulation Act are
Here-
to be, for this purpose, to be treated
Principal
as the.
employer
No, my
is
lord.
liable to
The
pay.
principal employer.
Principal employer is
no.
liable to pay for the contractor's
That's only, my
employees.
lord, in
The scheme
cases.
specifically provides for that, my lord.
Which section provides?
My lord, the scheme, my lord,
Scheme provides.
please, my lord,
Yes.
the Employees Provident Fund Scheme.
And even your lordship may kindly see in EPFC definitions your lordship may kindly. 2F for the time being. 2F employee. Under definition, employee means any person who is employed for wages in any kind.
Contractor.
Please, my lord,
Through
through a
contractor.
contractor.
And then, my lord,
My lord,
para.
para 30 of the scheme, my lord.
Then
will
for
say
what,
arbitration.
on what ground you are seeking remand?
My case, my lord, is that there are contractors. Here, contract labor is not abolished, so I can take contract labor. So there is a contract labor that is employed. The contractor has discharged it.
The contractor must have a license under the Contract Labor Regulation.
Yes, he has discharged his liability. That is my case. And I have material, my lord, what happens is this, my lord, the contractor will submit me a monthly bill. In the monthly bill, he'll tell me X number of employees he has got who have worked, Paura Karmikas. And this is the provident fund which is payable relating to them. And they have to produce proof to me to show that they have paid the provident fund. Only thereafter I discharge their bill.
My lord, may I just make one submission, my lord?
You
My
are
lord,
for-
I'm for respondent number 1, my lord. I'm on caveat. I was the petitioner in the petition. I am for the union, my lord, union of the workers who filed the complaint. My lord, this complaint was filed in respect of non-payment of PF amounts for the period 2011 to 2017, my lord. 2017, the PF commissioner passes an order under section 7A of the act, my lord, saying that this is the amount that is due. In fact, they go through a detailed inquiry and then they pass this order. That order, my lord, there was a review petition that was filed against that order. That review petition came to be dismissed, my lord. Neither the order under section 7A. In fact, my lord, there is an appeal against the order under section 7A under section 7I, my lord, to the tribunal. Neither the order under section 7A nor was the review petition was challenged anywhere. Even as of now, it has not been challenged. Since this order was not implemented, my lord, I approached this honorable court in the writ petition seeking that this order be enforced in order to ensure that it is implemented. It is on my petition, my lord, that this order came to be passed. In the meanwhile, my lord, there was an order of attachment that was issued by the PF Commissioner's office, which was challenged by the BBMP. But the order under section 7A, my lord, which was just now read out by Learned Senior Counsel, that has not been challenged at all, my lord, till now. In fact, my lord, the appeal provisions under the EPF Act, my lord, it specifically provides under section 7I that there is an appeal to the tribunal. That appeal has to be filed within a period of 60 days, and the maximum period of condonation that is permissible under the law is of another 60 days. This order is dated, my lord, 26/10/2017. This order has not been challenged anywhere, my lord. This entire amount, my lord, is in respect of about 30,000 workers who, for the period from 2011 to 2017, in respect of whom PF contributions were not made. In fact, my lord, under the scheme, under the EPF scheme, para 30 of the scheme, my lord, specifically provides the Employee Provident Fund scheme, my lord.
Subclass 3 of section, para 30.
30.
Please, my lord, 30. The employer shall, in the first instance, pay both the contribution payable by himself and also on behalf of the members employed by him directly by or through a contractor. The contribution payable by such member in the scheme referred to as the member's contribution. My lord, subclause 3, my lord. It shall be the responsibility of the principal employer to pay both the contribution payable by himself in respect of the employees directly employed by him and also in respect of the employees employed by or through a contractor and also administrative charges. So the law is very clear, my lord, that even if they are under a contractor, the amount will have to be paid through the principal employer. And a detailed inquiry was in fact held into this matter, my lord. And these workers, my lord, even as of now, they have not, this relates to a period from 2011 onwards. Lord, may I just
The
make one more
documents may not
submission, my
bear
lord?
out, the documents have produced, my lord, in the additional set bear out. It gives the name of each of the contractor. I agree, my lord, that that's an obligation of the principal employer. The documents bear out.
So by this material, what you will be going to establish?
My lord, what I will establish is that all the Paura Karmikas who are working, because up to 2017, my lord, they were on the rolls of these contractors. Post 2017, we have taken all of them on our own record. So they are today our employees. For the period 2011 to 17, the contractors under whom they were working, they were all registered and each of them has got a PF number. I given full details are available with me, which shows who is the contractor, how many employees Paura Karmikas are working with
So
him.
the obligation is discharged.
Yes, obligation has already been discharged and each of them have got credit and this information is given to them and it's available. If your lordship could just.
So there is overlapping of payment.
It's all available, my lord. Everything is available. In fact, that's why, my lord, I didn't file it there. I filed it with your lordship's kind permission in the appeal. If your lordship could peruse some of them, it is not some third-party documentation. Full details are there. What is PF code is there? How many employees are working? Proof of payment. That's why I submit the procedure we follow is this model. Whenever a contractor submits a bill to us for his payment, we first verify whether he has deducted PF. Has he paid the PF? Only after satisfying that.
What is wrong? Now today you have
recovered the money.
With your lordship's kind leave, my lord, in the 7A order, your lordship, please kindly look into page number 48. The 7A order has been initiated against the BBMP for only one single account, that is BGBNG 44679. Whatever the account numbers which they are showing now, establishing that all the contractors have paid towards the PF account are all different. It's not same account. There are many contractors who are working and there are many employees who are working under the contractors. We do not know whom they should have punished at that time. Your lordship may kindly see the account number under 7A was entirely different. Not this account numbers what the learned senior counsel is furnishing now. If at all it was there, it were part of the record in before EPFC also, they would not have initiated. If the same account.
Just to clarify, my lord, to my learned friend,
Yes.
my learned friend is right. The notice which is being referred to here, the document I have produced, I have only a sample relating to one division. I have exact similar documentation regarding every division. There are in all 8 divisions and each of them full details are there. And all of that is available and can be placed before them. It is available with PF authorities also. Only they had to match it and I plead, my lord, I am guilty.
No.
The corporation, my lord, should not have conducted itself in the manner in which it has done. They should have placed the material. I'm a public authority, my lord. Give me one opportunity, I'll place it before them.
My lord may just have a look at at page 56, my lord, of the 7A inquiry. In fact, my lord, these aspects have been considered. There is a report by the enforcement officer who has looked into all of these documents.
But are you saying that there is a double payment?
What I'm submitting now, the demand now made, my lord, is a demand made without reckoning the payments already made for this very period by the contractors, for this very employees.
Can't even say. And continuation of that page also, your lordship may kindly see. At page number 51, a table has been formulated and has been produced. At page number
In
51.
fact, at different stages,
My
the
lord,
PF
in here, if your
authorities
lordship may kindly see.
verified the records, my lord, at divisional level. I have with me, my lord, certain letters issued by the PF authorities to say they have verified the records of the contractors and the information which we have given, and they are satisfied that they have discharged all this obligation. Such letters are available with me.
The table is very clear. As per the table, my lords, the total number of employees engaged as per the contract, total number of employees for whom PF paid as per available
Here
records.
that there is some material indicating repeat payment.
No, but no, account numbers
Not
itself
double.
is different, so
In for some period or some part, some segment of the.
no, that is what they have come out with a new version.
Now they are.
But yes, but if your lordships look at this also, in the table, it has been clearly mentioned where the PF amount has been received by the employees, and even that list also has, why not maybe this? If that is the case, because your lordship, just now, my learned senior counsel has read the entire order. In that it is mentioned that wherever they could find that PF has been paid by the contractors, that has been elicited here. In para B, that is at page number 51, and zone wise it has been mentioned. Total zone, total number of employees engaged as per the contract, total number of employees for whom PF paid as per available for details, because those documents were produced before the 7A inquiry, and there it has been extracted. It is not that it has been ignored. The documents wherein the employers have been paid. So these documents, wherever documents were not established, that the payment of EPF, that is Provident Fund has been paid towards the employees' contribution and employers' contribution, only those cases were referred. And accordingly, as per that, even though the documents were produced, there was no payment register and other things. Hence, it has come on this line that estate and assess management articles, everything, expenditure and everything has been done. Para 3. Apart from above AB, page number 52, my lords. A comparison of expenditures incurred in the schedule head and salt, everything has been elicited. It is not that it has been passed. And even before your lordship in the appeal, the 7A order, which has been challenged in the writ petition, was not challenged. The writ petition filed by my learned friend, that is the Sangha, has been challenged, wherein they have sought for compliance of the 7A order. And hence 7A order even till today remains intact. It has not been called into question.
My lord, may I submit this, my lord? After complete inquiry into this, after looking into this, my lord, the enforcement officer made a complete report on what has been paid, what has not been paid, and submitted it. On the basis of that, and after the BBMP was given an opportunity to reply to the same, in fact, my lord, that's what is specifically mentioned, what was read by learned senior counsel. After they were given an opportunity, my lord, the 7A order came to be passed. That order, my lord, has never been challenged by them. There is an appeal provision which they have not filed an appeal on. In fact, my lord, that 7A order has reached finality. And it is a writ petition that has been filed by the union asking for the enforcement and implementation of the order, where the learned single judge has allowed, saying that 7A order has reached its finality.
Oh, the order which you are challenging of learned single judge inter says that BBMP is directed to comply with the order dated so and so and deposit the amount along with interest.
Yes.
That amount is deposited.
Yes.
They
have now received the money.
Yesterday we have received, the amount has been deposited in the bank.
Directions have worked out for itself.
Yes.
These directions are worked out for itself.
That's true, my lord. Whether
then how would it be?
If I succeed, my lord, before your lordships, ultimately,
would it not be impropriety if even if we accede to a request to pass some order?
Yes. No, my lord, the authority has passed an order. The learned single judge, my lord, has given a direction that we should pay. I have paid the money. I have now in appeal. If your lordships were pleased to, my lord, send them back. What should happen to this money is left to your lordship's kind discretion, my lord. Whether I should be deprived of it or it should be with them. I'll give a bank guarantee. I'm public authority.
My lord, two submissions, my lord. One, my lord, the petition is filed by me. The petition is filed by the union for the enforcement. In that, my lord, whether they can even seek this when they have not, when that order has attained finality. In my petition, my lord, that is one. The second, my lord, these workers concerned herein, the Paura Karmikas, my lord, are the people who sweep the streets, sweep the roads. Several of them, my lord, these are amounts that are due from 2011 onwards. This has been going on from then. We are now almost 14, 15 years later, my lord. Still that amount they have not seen the light of day. They are the most downtrodden, my lord, if you have to look at it. So given that, my lord, it is my petition. In my writ petition, this appeal has been filed.
A separate appeal, my lord, in order passed in my writ petitions also on the anvil, my lord, it is being filed. Because the learned judge passed a common order in two writ petitions. One in my petition and the other one is filed with the workman. This appeal is arising from the workman's writ petition. My writ petition was dismissed. Against that also separate appeal is being filed.
My lord, the order of the PF authorities has attained finality. That has not been challenged. Even in their writ petition, it was never challenged, my lord. This order has attained finality. Having attained finality, my lord, and being an order of the year 2017, whether now it can. No, please, my lord, this order was never challenged, my lord. No, my lord, 26/10/2017 was not
Never
challenged.
challenged.
Never challenged, my lord. My lord, what they challenged, my lord, is after this order was passed, there was an order of attachment that was issued. Only the attachment order, my lord, it's there in the
It's
order of
here.
the learned single judge, my lord.
No, I have
Only the
petition
order of
copy.
attachment was challenged.
I have a petition.
This order was never challenged, my lord. An order that has attained finality in 2017, whether they can be permitted to reopen it when I asked for the enforcement of the order, my lord, given that it was never enforced. When I asked for the enforcement of the order, can they now seek for that, my lord, when everything has in fact been gone into? In fact, my lord, learned single judge
Page
specifically
number
notes that-
19, page number 19 may kindly be seen. In another petition, they have challenged only attachment order, not the order passed under 7A. That's.
Please. Please. Please.
And whatever they have served on me, that is a PF, the account numbers also.
Yes, my lord.
Yes, my lord. Yes.
True, my lord. That is because in their petition, my lord, they wanted this order to be enforced. So I am defending to say, please don't enforce this order for these reasons.
Lord, that order having
That's the
attained
submission I'm
finality
making. And
should have
I filed
actually
a
been
separate petition.
Unless a
Could have been
7A
enforced
order is
without me
set
coming,
aside,
my
madam,
lord.
it can be done. And that cannot be done now because of the paucity of time.
In fact, my lord, I should not have had to
I
come to
filed
the
a
court.
separate petition to say they are trying to enforce this order. Please prevent them from enforcing. Yes, my lord, that petition, that's what my learned friends are pointing out. In that petition, what we challenge is the order by which they want to enforce that order of 17.
That's what,
In their writ
attachment,
petition,
attachment.
There
in
was
their
an order
writ
of
petition,
attachment, my lord, which was.
they say, please give effect to that order. So I'm saying, please don't give effect to that order for these reasons.
But 7A remains
Technically,
intact.
my lord, I think they are right. I don't want to stand on that formality because technically they should have challenged that original
Yes,
order itself.
yes.
But I'm saying it makes no difference.
My lord, they actually have an
my lord,
appeal,
in
my
this
lord, but
case,
it's worked
the-
with-
7I.
the independent remedy, my lord,
Statutory period is only 90 days.
then, my lord, it may be appropriate for the authority itself to adjudicate it again, my lord.
My lord,
Because
that has been,
if the PF authority, my lord, looks into this, my learned friend to some extent is right. Ms. Anand saying,
my lord, they did that, my lord. A
That-
review petition was filed and
if
rejected.
your lord,
The review petition was filed by them
no,
and it was
review
rejected.
petition was dismissed with a one-line order, my lord.
That also has been
And that
done.
has also not been
Review
challenged.
petition just says no ground dismissed.
My lord, the entire thing,
Yes.
No, not
Yes,
against
7A,
this.
7A.
Against the
Against
first order
7A,
of 2017.
my lord, against this, a review petition was filed. It was dismissed in the year 2018. Yes, my lord.
Yes, yes, ma'am.
Review
Yes,
has
review
also
was
been
also
dismissed.
rejected.
It has been, yes, my
Yes.
lord, it has been
No
rejected.
new grants were made, so hence rejected.
My lord, what has happened is that this order was there, it was not being implemented. We came to the court asking for it to be implemented. In that, my lord, now they are saying that that entire order itself, which has attained finality, has to be redone.
Please.
Unlikely
Not
to
the-
have
the money is
double
now
payment
lying with
because
them.
of the reason of different account numbers.
Please, madam.
I'll mention that.
The money is now lying with them, Lord.
Yes, ma'am. Yes, ma'am. I'll do that. ma'am. So that I'll clarify, ma'am, because. Yes, no, I'll go by whatever the accounts, whatever the. account
Ultimately,
numbers
my
they have
lord,
made.
We are in difficulty
your
because we have
lordships
not
are
seen it.
court
madam.
of equity first, then court of justice. In India, my lord, the situation is different. So, my lord, what I'm submitting is the party before your lordships, my lord, is a public authority.
Whether it's
Now,
same-
if I've got, I completely not plead guilty. That's why I submitted at the very outset. The manner in which this litigation has been conducted by BBMP, my lord, is a classic case of complete apathy to how litigation must be conducted, how officers should look after it. They have not done so. They have not done anything diligently. But nevertheless, the public authority may be protected. Please,
Wait.
some form of review, my lord.
No, I'll just produce the account numbers and following with the data, whatever they have produced. We have those data. Minimum 10 to 15 days, madam, because it's 15 days minimum. Very well.
My lords may, please, madam.
Convenient to this.
But one request I have, my lord. I'm in financial, my lord, stringency. I'll give a bank guarantee for this amount, my lord, if they return that money.
If they have 700 crores still there in the bank there, I found out that also.
Lord, I have huge, my lord, for an elephant, my lord, a banana is of not consequence.
Lord,
Now, I'm in a situation,
It
my
has
lord,
been encashed and all these
where
separate
I
bank
need this
accounts.
money, my lord. I'm in.
I'm sorry. Come, on, you say it is workers' money.
My lord,
I'm
learned
not
senior
going to,
counsel had
my lord,
said, my lord, this
go
is, my
away
lord,
anywhere. I'm before your lordships, my lord. Ultimately, whatever order will come. But
No,
this
it's a
money, my
workers'
lord, has
money,
now
even
been
PF
taken
will
away
not
from
take it.
public
It
but
sector.
this is a
pertains
court of
to
equity,
workers.
my lord. The workers concerned are those who are cleaning the sweep the streets every day, my lord.
No,
They are
but-
the ones who are the poorest of the poor who have never been able to raise their voice.
But
That is
today,
the
my
reason
lord,
for almost 6 years, my lord, this could happen, that the PF was not deposited to their accounts. They are
Lord,
the
if
people who
this-
could not do anything, my lord. These are the workers, my lord, and like learned senior counsel said, there's a court of equity, my lord. These are 30,000 workers who have not seen the PF amounts from 2011 onwards.
my lord, if this money is with PF authority, my learned friends' clients are not going to get it today.
No,
It's only going to be in their account. So they are not, today they don't have the money in their hand. I'm not telling them to give it back. The Provident Authority has got the money.
Like the,
If they give it to me, my lord, I'll use it for public good. I'll give them a bank guarantee.
No. Feels- We don't have any authority.
Because, my
to
lord, I've
even
challenged the order and during the pendency of this writ appeal, my lord, before the matter could come up before your lordship, they've encashed it.
They have given notice. Everything has been followed. I brought that also original documents.
I sought stay, but
Not
before
come.
that could be considered, this enforcement has taken place.
3 months before we have issued notices. We will calculate it.
But we filed the appeal in March, my lord. I understand, my lord, my predicament.
3rd July.
Please. But I only hope that they don't now continue the damages and interest proceeding, because there's a direction that they're going to do that. Let that not be done, Manoj.
It's not
Otherwise,
there
we'll be forced to defend the further proceeding.
Will not.
Let them not proceed further on. Because now the learned judge's order permits them to go forward and pass an order under 14B, which is damages 100% plus interest. Ultimately, my lord, if your lordships, my lord, decide in my favor and the matter has to go back, then that will become
Please.
Seal number 12.
Respondent KDB's appeal, my lords. The petition was filed challenging the acquisition proceedings, my lords. The petitioner claims to be had filed an application for regularization. Lordship will get the prayer, my lords. Your lordship may kindly see the prayer at page 48 for a moment, my lords. Page 48, my lords, is seeking to quash the preliminary notification dated 7/8/2006 and final notification dated 25/8/2007. His claim is, my lords, he has filed an application for regularization. Your lordship may kindly see at page number, my lords, 31 in the list of dates, my lords. At page 37, para 3, my lords. 37, paragraph 3 is seeking, we have filed an application for regularization under section 94A, my lords. If the, under section 94A, my lords, 194A, if the land is acquired, application for regularization cannot be considered. And it has been rejected, my lords. In spite of not being an owner, my lords, is claiming compensation for a land which is sought to be acquired. Not granted, my lords. Not granted, my lords. He is an unauthorized occupant, not granted. No, no, never granted. Till never granted. He is only pay compensation to him, my lords, at the rate of 30 lakhs per acre. Based on an order of the DC on compassionate grounds, my lords. This is that order compensation, compassion, page 150. Challenge was to acquisition. Not decided at all. Not decided. In fact, his case is, my lord, only a landowner can challenge acquisition. His case is, I am an applicant for unauthorized occupation, but and under section 94A, my lord, clearly says, subclause E, my lord, clearly says, if the land is acquired, is not entitled to be considered. Kindly permit me to. Your lordships will get it at page number 30, at relevant portion is at page number 29, my lords. The last paragraph, KDB shall also ensure that the terms of deputy commissioner proceeding dated, so the allottee company shall employ at least one member of the family to the petition appropriate position, so on, so on, so on, within 6 weeks. If the, That is regarding, we have acquired the land, allotted the land to various companies, my lords. Okay. In fact, these are the beneficiary of, after acquisition, we have given the land to various other persons. This has been set aside. These are the DC order. Confirm with the government. Ex gratia payment. No, question is, Manoj, person who's not. I'm sorry, Manoj.
They were occupying the land.
So they filed.
Whatever capacity, maybe as unauthorized occupants.
Please, Manoj.
So this compensation was given for occupation,
No, Manoj.
depriving them of occupation.
No, not that. Your Lordship may kindly, that recommendation, what recommendation of 22/7/2020 has been rejected by the government. As on 6/9/2021.
Where is that rejection?
That is at page number 224. Page 224, last paragraph. Manoj, there are hundreds of applications which are pending, Manoj, just because page 224, last paragraph, it is hereby directed that there is no provision to pay compensation or ex gratia compensation to the subject land, since the land measuring 14 was basically a government land and land acquisition process was completed 14 years ago. Page 224, last paragraph, Manoj. The order starts from, the page starts from 22/23 regarding payment of ex gratia compensation in respect of government land measuring so and so, so and so, so and so, beneficiary for person required, letter bearing now. So with regard to the payment of ex gratia, that has been rejected, my lords. It was only a recommendation which was considered and rejected. And section 94A is very clear on that aspect, my lords. Can I permit it to 94AF? 94AF, if provided that no land shall be regularized under this section, if such a land is falling within the land proposed for acquisition and is required for any project. So his application itself was not made, is not entitled to be considered. If his application is barred under 94A,
This is appeal by whom?
KDB. There's a direction to KDB. 94 capital A, my lords. Regularization of certain cases of unauthorized occupation by constituting a committee. Can I request, my lords, proviso, my lords, at A, B, C, D, E, F, your lordship will get, after subclause 4, after the table, my lords, after the table provided, my lords got it. my-
Provided that no such.
No
land-
such land be regularized under this section if such land, F, my lords, if falling within the land proposed for acquisition is required for any project of the state government or local authority, statutory of the state government. So therefore, my lords, KDB is the statutory authority of the. So therefore, my lords, the question of regularizing does not arise. And one more thing, my lord, unless there's an order of regularization in his favor, my lord, no right accrues. If this principle is taken, my lord, if just because he has filed an application, he is entitled for compensation, there'll be hundreds of people who will be asking, I filed an application, kindly give me compensation. Whether they're entitled or not entitled, it has to be considered by a separate committee constituted under 94A.
But only notice today.
Notice, my lord, in fact,
There is a delay.
please,
Or
with liberty to serve the counsel who appeared before the single judge, my lord. And only thing, if the contempt comes, my lord, only thing is contempt has been filed, my lords. And contempt number could.
Not in position to say anything. You are not in position to say anything.
My lord, this compensation could not have been paid. In fact, the government should have preferred an appeal against this order. I brought it to the notice of my lord, this, with regard to the application being rejected. The learned single judge, my lord, holds that the application is rejected, but at the same time directs that compensation is to be paid to them.
Or learned advocate general. She can set. Appellate. Notice returnable on 18th July.
Can I request, let it be connected with contempt CCC number 248 of 2024, my lords?
Where?
No date has been given in that. 248 of 2024.
To be listed with contempt petition number 248 of 20.
My lord, may I
Say
take,
that contempt petition number 248 of shall be listed along with the present.
Please.
my lord, may I take notice for respondents 5 to 8?
Additional round. Accept notice. Respond 5 to 8.
Obliged, my lord.
I'm given to understand it's on 7th June, my lords, Friday, the contempt petition.
It is coming on 7th June.
7th June. That is-
So on that day will pass in that contempt petition
Please,
to be listed.
please.
Pass the order of contempt. 7th June.
Please, when that will separately. I'm grateful to.
Obliged.
7th June, you remind.
I'll will remind you.
This is 230 matters, still number 64. Srimati Nita PC.
The complainant, they have complied. The ramps have been removed and the debris also have been cleared. So they have complied with the order.
Learned advocate for the complainant. Clearly stated that the order in the contempt is compliant. State the effective of compliance is confirmed by learned advocate, Mr. So and so and so. Yesterday's matter.
Yeah,
Yes,
yesterday
please.
I filed a affidavit with respect to.
Stated that the affidavit is filed showing the compliance. Nothing survives. In this proceedings, the contempt petition is disposed of as not served.
Please, please.
Number 65. Chandrakant R. Gole.
Appear to the complainant, my lord, is this yesterday's matter, my lord, my colleague appeared. Here, my lord. Here, my lord, the compliance report is stated you have been filed now. I would like to file, my lord, a detailed reply, my lord, to said memo. Now, your lordship kindly see the order, my lord, as per Annexure A, wherein, my lord, there is a direction to consider my representation for the purpose of change of khata, my lord, in persons to the said deed which I have purchased long before in 2012. Now they have come up with the reply, my lord, stating that there are certain objections and that the matter is pending before the Assistant Commissioner. When I presented a representation, my lord, in pursuance to the order of this learned senior judge, the Tahsildar refuses to accept. Assistant Commissioner also refuses to accept. And therefore, my lord, I make a representation to the Deputy Commissioner, who in turn, my lord, has communicated to the Tahsildar to take a call, to consider the application. Now, my lord, the endorsement is also appears to have been issued, which my client has not received. But there is no legal impediment for the Tahsildar, my lord, who is the competent authority, to effect a change of my name, my lord, in the khata, in the record of rights, in pursuance to the sale deed. Whatever that happens, my lord, to the change in the khata is always subject to any proceedings pending before any court of law. It is almost 12 years now that I have been struggling, my lord, to see that my name is changed in the khata. That is the representation, my lord, which I had made, which was not considered, and therefore I was compelled to file the writ petition. Long before in May 23, my lord, there is a direction at page 13 of the order, 13 and 15 of the order. And I have produced all the necessary documents, my lord, in proof of my request. That is my application for change of khata. Copy of the sale deed has been produced. And I have acquired a right at interest over the property. The Tahsildar is the competent authority to for change of land.
The endorsement is issued. There is a rival claimant in this land. So the revenue authorities don't have the powers of a civil court to adjudicate the title. So they've given them an opportunity to appear before the Assistant Commissioner. All that grievance, whatever he's mentioning here, all the grounds that he can take up before the Assistant Commissioner, and if he has a title, the Assistant Commissioner will
Now,
pass
your
the order
lordship can
to
see,
issue
my
the
lord,
khata.
according to my instructions, my lord, the proceedings before the Assistant Commissioner, my lord, is not in pursuance to an appeal filed by me, though the document says that. But it is a so much of proceedings initiated by the Assistant Commissioner, for which, my lord, I am really not concerned with. Let him issue a notice, my lord, I will answer him. But there is no impediment for the Tahsildar, my lord, to take a call on my application for.
Let them file. Rejoinder.
Pardon?
You want to file rejoinder?
Yes, my lord, your lordship, kindly. After a week or two, my lord, I will secure the affidavit of the party.
Whichever date you want.
Any date convince the court, my lord, after 2 weeks.
Yes, next.
Number 30. Ravi Kumar GH.
Lord, I appear for respondents 1 to 4, my lord.
No. So 30.
Number 30. Ravi Kumar GH.
My lord, may I seek for 3 weeks' time to file my statement, my lord? My lord, in this, what has happened is the encroachment of the land which they are seeking for is not revenue land, my lord, but it is the forest land. So the forest department has to be made a party in this petition, my lord. Revenue department has been made a party.
Oh, like file a reply.
My lord, unless the forest department is made a party, I cannot,
But the petitioner is not present. Let it go. 2nd July on that day.
Thirty-one urgent, seal number 32, Mr. Amrutesh NP. 32.
In this 30th,
32.
write down. Awaiting the presence of learned advocate for the petitioner in vain. And
my lord, in this I pray for 3 weeks' time, my lord, to file my statement.
3 weeks.
Obligement.
Number 33. Saurabh
Petitioner,
RK.
PIL at which the software for registration of documents in the state of Karnataka has been challenged.
My
And
lord, in this also I pray for some time, my lord. 3
What
weeks.
is this Kaveri software?
Yes, my lord, with regard to registration of documents. My lord, they say that since there is an interim order of stay by the Honorable Supreme Court, my lord, we have violated that and we have come out with this scheme. My lord, may I pray for 3 weeks' time, my lord? I'll justify my.
Lord, if I may make my submission regarding the interim prayer that we had sought for, because the state keeps making changes to the software and keeps implementing more and more changes. And then seeking time here, but the thing is, it is becoming entrenched, the software. It is therefore
My lord,
short date may be given, my lord,
My
state
lord,
may be
I'm
directed to do
constrained
it
to
quickly.
move for some time because of the MP elections, my lord. The officers have just returned this morning to the office
My lord,
and
I'm
I've
not
kept them
objecting to
present.
adjournment, my lord. I'm only seeking that it may be done.
No, the
quickly. That is all.
entire
Because it's-
registration process throughout the state will come to a halt.
Exactly, my lord. That
Virtually.
the entire software is
Exactly. Can
illegal,
you
my
give
lord,
us-
is our contention, and I've produced an entire list of authorities for the same. I pray they are entrenching the software into other softwares and into the other processes of the state so that it cannot be quashed later on. It will become impossible. The entire state mechanism will come to a halt if it is quashed subsequently. That is how they are making it a fait accompli, my lord. That is why I pray for short. I'm not objecting to adjournment, my lord. I'm only praying that it may be done quickly, my lord.
July 18, July.
Very well.
Much appreciated.
Number 34, the Ravi Shankar K.
This petition kindly call along with serial number 55, my lord. And the last date of hearing, my lord, dishonorable court has tag on with the serial number 55. The oversight today is not tag on. Serial number 55, my lord. Identical
Yes,
matter.
he's asking for time.
What do you want? What do you want?
This petition kindly call along with serial number 55. Serial number 50.
55 can be taken with this. Why this should go with 50? Now, 55 can argue.
Lords, this is the matter, my lords, with respect to the tax basis survey. In the senior council had argued, lords, on last date of hearing. AG submitted in the last date, my lord, stating that since the code of conduct was there, my lords, will not precipitate the matter. Hence, my lord, the matter was urgent for the present date. Now, my lords, the matter needs a detailed consideration, my lords. Our only anticipation is, my lords, the person, my lords, who was heading the commission, my lords, has been participated in the election. My lords, in the last nth moment, my lords, this has been submitted. From 2014, my lords, this particular commission has been done. And my lords, after 10 years, my lords, the same has been accepted. My lords, let the government not precipitate, my lords, till the matter be decided. It's only my prayer.
My lord, we are not precipitating, my lord.
Yes,
My
my
lord
lords.
may call this after
Lords,
2 weeks.
in
My
the statement, my
statement
lord,
is
the chief
ready.
minister has given
I
a
will
statement
file my
stating that, my lords,
statement,
they
my
will place
lord.
it before the house.
Do not file so.
My lord?
Reply is not.
My lord, after 2 weeks, my lord may have this. My lord, the statement
Till
is
then,
ready, my
let them
lord,
not
but couldn't
precipitate,
be
my lord,
filed
because
because the
just-
officer
just
was not available.
What is to be precipitated?
My lords, if they place it before the House, my lords. The last date of hearing, your lordship was about to pass an order. They said that, my lords, will not pass any order till the elections are
Still
done.
they have not placed people there.
Nothing, my
My
lord.
lords, the same may be recorded, my lords, and be posted. We are ready to argue the matter, my lords.
You filed.
My lords, my humble
I'll
submission
file it,
is,
my
my lord,
lord, it's
from
ready.
2014, my lords, nothing has happened. Till, my lords, if,
So then why do you want?
because, my lords,
My lord, a short
Matter is
adjournment. I'll
pending.
file it tomorrow, my lord, and my lord may have this, my lord, anytime within a week.
the matter is pending from
Within a
2015.
week, he said.
Yes.
So it is fair enough. This is which serial number? 42,
34 and 55, my lord.
54 and 55. Learned additional government advocate, Ms. Neela Forshaw. Waits for time to file reply. Send over to 24th.
Obliged.
Lords, let them not precipitate till then, my lords, as per their oral submission, my lords.
My lord, I don't
From
know why these
2014, my lords, nothing
submissions
has
are
happened, now,
made.
my lords.
It was requested and requested
My
several,
lords,
2, 3.
the matter is of 2015. They are keep taking time, my lord. The central government has filed objections, supporting the contention of the petitioner, my lord,
Same
stating,
request and prayer was repeated and repeated. We have not granted. Let them file reply.
my lords, as finally, my lords, maybe not.
Only 24th.
Please,
Obliged. my lord.
can I request for 2:30, my lords? Because this matter needs consideration, my lords. All the senior council will be present on that day.
Senior councils are coming only at 2:30.
Please, matter is pending from 2015, my lords. Nothing has happened. The
We'll
government
take
is
up-
not taking it seriously. It's only my submission.
We'll take up, don't worry.
Please.
All matter we are inclined to take, provided we have. We'll take up.
Please.
In fact, it was, you are not there before vacation, it was almost started in 5th gear, but then somehow did not proceed.
Yes.
It started, it's really started, we started the hearing. So there is no reason for you not to say that we will not hear them.
Please, my lords. Obliged.
It's number 35, Sumuto writ petition PA.
I appear for respondent number 7, my lords. I have recently filed my wakalat, so seeking a short adjournment to file my response.
Oh, this is that matter.
AGA has served me a copy with the affidavit, my lord, today afternoon.
What affidavit will file? You have to show, you assist us the court in evolving a mechanism. That is how fast you can comply with the court's order.
All the complaints are satisfied. All the 10 complaints are satisfied. Under the chairmanship of the chief secretary to follow with all the.
Put on affidavit.
Yes, we have an affidavit of the chief secretary.
This is AI side. My lord, may I make one submission? My lord, along with that, my lord, we'll be filing an additional statement of objections, my lord, meeting, my lord, the contentions that have been raised in this writ petition. My lord may grant us some time, my lord.
Will grant.
Obliged.
To stop the filing of contempt.
Yes, my lord, that is what I was
Yes.
discussing with the learned advocate general. Obliged, my lord.
So file. So that litigation is
Yes, yes.
reduced to that extent.
Yes, ma'am.
You will be at a loss.
Yes.
So assist us on when shall we keep?
My lord,
File
after,
whatever reply you want to file. You are for whom, mister?
I am for petitioner, my lord.
For High Court.
Yes, ma'am. R6, 7 and 8 have to file.
What
the
is your
resp-
name?
Venkat Narayan.
Venkat?
Venkat Narayan.
Venkat?
Venkat Narayan.
Right. Narayan. So when, somewhere in July?
yes,
Fourth-
my lord,
4th July?
very well.
Very well. Please, keep your.
Obliged, my lord. बोले तो सुनते नहीं, हाल ही तुम्हारे हट हो रहे हैं।
Number 36.
May it please minutes.
Therefore, respondents 1 and 2.
Millets. May it please. Millets, the second respondent is a statutory board. The modus operandi, Millets, just to put that in a nutshell, the government acquires the lands and hands them over to the statutory board with an avowed objective of developing industries. And Millets, in turn, the second respondent invites applications and allots to the prospective industrialists of whatever hue and color, Millets. In
What is
this
it?
case, Millets, they
Industrial plot.
allotted,
Industrial plot.
indeed, Millets. In this case, they allotted a plot to me.
Yes.
Millets, they allotted a plot of 10 acres to me. During the COVID, they say that they sent notices to me demanding payments. And they say that I've not complied with that one. And they say that after sending a notice, they canceled it. The notice never saw the light of the day. I never received it. It's an admitted fact. Then, Millets, it was reallotted to the third respondent. Millet's allotment, cancellation, reallotment is the mantra the board has been very much familiar with, and everybody knows Millets. Then, Millets, your lordships on earlier occasions in this matter wanted to know the truth and to read between the lines because the countess never revealed the whole picture, directed the second respondent to file particular affidavits with regard to aspects. Even then, Millets, they could only speak half-truths, never to the satisfaction of your lordships. Millets, the cancellation was mired in controversy, a fraudulent act on their part, I must say, using this strong expression with apologies, Millets. And then, Millets, the allotment to a third party, there's a third respondent. Again, Millets, it's a sort of a foregone conclusion on their part. They chose the preferred person, and then they initiated cancellation against me. Within no time, they could allot it to somebody else, disregarding whatever others that have been waiting. In that context, Millets, before I could begin my submissions, may I crave your lordship's kind indulgence, Millets, if my lords could summon the records to know how the cancellation has been effected and how the subsequent process has taken place and how the allotment has happened in a jiffy, overnight, in favor of a partnership firm, which has already had 5 allotments. To this day, I'm told, Millets, in fact, we put that on affidavit as well. Not even a brick has been put over there. The same partners constitute another one 3 months prior to the cancellation of mine, and then they get that one, bypassing everybody else. And that could be writ large and Millets, loud and clear, if my lords could have the opportunity of looking at the records. Lest, Millets, based on the record, I could proceed. Though I filed the writ petition minutes at the earliest point in time, unfortunately, at the admission stage, it was dismissed on the premise that the court doesn't want to get into these aspects of allotment, cancellation, and reallotment. That apart, it has observed that I did not adhere to the time frame. This is all that's been spelled out in the impugned judgment.
So it was a kind of a auction.
It's a, my lord, allotment, my lord, in pursuance to, my lord, Industries Facilitation Act. My lord, in state of Karnataka, there is an act called Industries Facilitation Act, which clears all the industrial projects, my lord. And my lord, on the basis of the clearance granted by a single window agency, the allotments are made by KIADB. In this case also, initially in the year 2017, allotment was made in favor of the appellant before the lordship, my lord, on the basis of single window committee's clearance only.
What is the procedure for determining the price?
Price is decided by the board, my lord, on the basis
The
of,
board.
yes. Board, my lord, develops the land on the basis of,
So you invite the applications.
yes.
You invite the application.
We invite applications as well as, my lord, single window, my lord, also grants, my lord.
This one were 3 was in picture when the.
My lord, he was not in picture, my lord, when the.
How he entered.
Yes, my lord.
Entered the.
Yes, my lord,
area.
I'll explain. Can I pass on this synopsis, my lord?
Minutes.
After cancellation.
Then.
Cancellation was done, my lord, on 30/4/2022.
In
30th April
Mills, may I
2022.
pass on, Mills, that your
2017
lordships
is their
kindly
allotment.
my note of submission so that that could aid your lordships in wading through the documents.
My synopsis may kindly be seen, my lords. In fact,
Well, it's
we-
broadly, in 2017, they're allotted. 5 years,
Also,
they
my
don't
lords
make the
could see,
payment.
Millards, the series of directions passed by your lordships in the order sheet.
So there is no prayer on your part against number 3
Indeed, there is. Millards.
in this writ.
In the writ petition, there is.
There is no prayer.
There is a prayer.
There is.
Millards, I'll come to the writ petition, Millards. Thank you. Page number.
Prayer is only to cancel your termination.
Millards, the reallotments also, Millards, one moment. Which is the page number? My lords may kindly come to page 70, if I could lay my hands on.
Therefore-
Millards, there are a series of prayers that's been Millards. Issue of mandamus,
It is
1, 2,
allotting
3.
the said land to number 3.
Setting aside the order dated so-and-so, audit committee so-and-so Millards. Allotting the said land to respond number 3. Prayer 4, my lords could see. Yes, Millards. It's a consequential one. They would come into the picture only if the board could sustain my cancellation.
But you don't pay the amount for how many years?
5 years.
5 years.
Millards,
5 years.
Millards.
Several extensions.
Millards,
And then, my lords, now we have registered it. We have put up construction.
I'll explain the
occupancy
whole thing,
certificate.
Millards. I'll explain how they have registered, how they have put up the whole thing for construction, Millards, given a chance. What I felt, Millards, if my lords are willing, the record is summoned, the whole picture will emerge, how this cancellation has taken place behind my back, and how this reallotment has also taken place. That gives the whole picture. Instead of either of the parties laboring to convince your lordships. That apart, Millards, I could submit.
In course of the hearing, if you find that the record is necessary, we'll call.
As your lordships, please, Millards.
But now at the threshold.
As your lordships desire, Millards. I only put forward that there's more than what meets the eye in this case for
Primary
that
reas-
purpose.
Primary reasons of your cancellation is the non-payment of 17.5 crores.
5
My
years
lords,
plus,
may I
5
appreciate one
years
thing.
plus we waited, 6 notices were issued. In spite of the allotment letter itself providing that in case of non-payment within 90 days, the
Millards.
allotment offer stands automatically cancelled. In spite of that, we showed indulgence for 5 years.
Litigation was
And my lord,
pending. Litigation was pending.
For-
Their officials could not.
Pardon,
You are for.
I am
The
KID
board,
for
Millards,
KID.
second respondent board. Millards, when they allotted that to me, litigation was pending between the farmers who owned the land and the board, including the government. Both civil suits and writ petitions were pending. And I requested that you need to provide me access and also my basic amenities so that I could implement my project. And then Millards, they try to go out there to establish electricity, etc. They were chased away. They filed police complaint. Under these circumstances, I take demand drafts for the entire sale consideration, the balance sale consideration. I send them the photocopy. Look, I've already deposited in the bank in your account. All that I have to deliver is give the physical copy of this demand draft. Please provide me all the amenities and possession free of this one. I'm willing to give. I'm an NRI having a huge profile, and I've said that one. And every now and then I've communicated with them. Then Millards, deliberately, they send, rather allegedly, notice to a wrong address, and then they cancel it. Millards, I could understand if there had been any bona fides in that part, that as per the waiting list, etc. That's why, Millards, I was submitting to your lordships about the record, that it had been allotted to somebody who had been deserving and waiting. That hasn't happened. Straight away, a person who had already been granted 5 times, who had not put that, a realtor admittedly, says that his business is that of infrastructure, when the very purpose and the objective of the act is that of industry development, not infrastructure. Infrastructure is the duty of the board, not the parties that would get in their place. Millards, in that circumstance, straight away, a partnership was registered, and then Millards, within 3 months, the whole thing was processed, and the board initially rejects, saying that the project you had submitted would not be fit in 10 acres, and also part of that is beyond the objective of this one, so we would not entertain. Then they themselves, suo moto, take into account and then cut off whatever is not falling within the purview, and they allot it. In that context, Millards. But anyway, Millards, I've given my notes. My lords may kindly go through that one. That will reveal the picture. Should I take your lordships through that one, minutes?
We'll fix up on some other day because today we are rising at, for 10 minutes is left.
Millets, I believe both me and my friend come from the other place. If my lords could accommodate tomorrow also, we are willing to continue, Millets. We are on vacation.
You are coming from outside
Delhi, Millets.
Delhi. Start right now. Whatever time is left, you can argue. Then we
So that I can continue tomorrow.
Tomorrow.
So, grateful, Millets.
Now give the facts. then.
Yes, Millets. Millets, the note is comprehensive in my humble submission, including chronology I have submitted, Millets, so that I can run through that one and then I'll explain my points within a short span of time possible, Millets. As my lords could see at the very beginning, Millets, I have put it as conspectus. Millets, the appellant before your lordships is an US-based company, Millets, having a specialization in IT industry, Millets. And then, Millets, my lords could see when it comes to the allotment that had taken place, I'll take your lordships through. Then when it had been cancelled and I came to know about the reallotment, Millets, I filed the writ petition that was dismissed. I believe, Millets, without notice. And then, Millets, I am before your lordships in this writ appeal. Now, my lords could come to the next page where the brief events have been set out in chronology. As they said, Millets, it's 20th January 2017. My lords could get that one. The initial proposal. The appellant to develop the IT industry in so-and-so had applied to the respondent number 2 board seeking allotment of plot measuring to an extent of 10 acres. Respondent number 2, under its 96th level single window state level committee, had allotted 10 acres, Millets. I'll take your lordship to the proceedings as well. Then, Millets, on 20th April of the same year, the appellant paid 6 crore 66 lakhs, Millets, and 50,000 as well, and he got the acknowledgement. Thereafter, Millets, he paid 7.5 crores. That was on 2 dates, Millets, 25th May and 31st April 2017. Then my lords could see, Millets, the allotment letter was given, that was on 6th June.
Even tomorrow.
We are in your lordship's hands, Millets, as per your lordship's.
We are not in that way seeking time. but
Any time as your lordships may please, Millets.
The bench is not available day after tomorrow.
Oh.
And tomorrow in the afternoon, so very less time will be able to.
My lords could accommodate us any other day, Millets, so
Because of
that
some professional engagement. the
I
bench is
do.
not available.
any short date possible.
Whichever both of you, and when on that day we'll take up.
Monday. Monday, Tuesday.
This is of which year? Recent? 23. Any date you choose. You can choose.
Well, it's, my friend says Monday, it could be.
If 10th is okay, my lords, the court.
Second half we can do.
10th at 2:30, my lords? Grateful. lords.
10, 2:30, I am in a part-heard matter, my lord. Can it be? my lord,
Their role
day
may
after
not come
tomorrow?
immediately.
Day after tomorrow, my lord.
No, no.
On 11.
After bench is not.
Yeah.
Lords, Monday, my learned friend can start. I can finish his parted and
Can,
come.
my lord, argue it, my lord, on the next date, that is 11th, we may be, my lord.
11.
10th, I'm there, my lords. I'll respond. If my learned friend can join, it's possible. my
10,
lords.
10.
Yes,
Let us see.
yes,
10
my lord,
minutes.
please.
Will be ready.
Harvard matter.
Minutes, if we are not stretching your lordship's indulgence too far, could we ask for
there is-
top of the board, something like that?
We want
So that we
continuity.
are sure that it could be finished within.
Since both of you are coming from outside, we want continuity in hearing. that
Yes,
is-
and my brother is both the ways, millets, he's half here, half there, but I'm only there. I'm not native of this place.
Well, I'll seek indulgence, my lords, to appear on 13th online, my lords, because I have.
Pardon?
I'll seek indulgence to appear online on 13th, my lords, because I have matters kept for 12th and 13th. That's why, my lords, I was requesting if it's possible this week or, my lords, on Monday, so that I could finish and go back.
Not possible. is not
Understood.
possible.
Understood.
We are
13th,
not
I am willing.
Understood.
online, come on. Or 17th can be the date, 17, 18.
17th
17th is holiday, I was told, millets.
Let's
17, 18 is.
my lords may not take it from 15th. No, no.
Seventeenth.
My lords, I'm sorry, my lords.
Sorry, 18th, 19th, 18 or 19.
My lords, the difficulty, my lords, Supreme Court is closed for vacation,
Opening
my lords,
on-
we are all out, my lords, after 15th.
Millets.
Opening on 7th July.
My
True,
lords,
millets.
Yes, my lords.
We will be
And my
leaving
lords,
the country for.
It doesn't allow us to appear online from out of the country. It does not, my lords, we have tried.
13th you may appear.
Grateful.
15th, millets, 13th.
You
I would
will
have-
not have benefit of your.
My lords, it would be a pleasure, my lords, to be in person.
Very good. 13th.
13th, grateful, millets, deeply obliged.
Grateful to your lordships.
Meanwhile, millets, if you have not. So please, record may be summoned, if your lordships feel inclined.
Pardon?
Record may be summoned because there is a gap.
In course of the hearing, if we find, we'll certain. But not as we said at the beginning.
So be it.
Permission. Serial number 57, my lord. The compliance of the office objection, translated copy. Translation copy. 57, my lord. Maybe 2 weeks' time may be given.
For
Translation. to
translation.
Furnish the.
Who has asked for translation?
Pardon?
Who has asked for translation?
Office raised the objection, my lord.
Office.
Serial number 40. And there is a stay, my lord, in that. There is a stay in, stay may be extended. 57.
Serial number 42, the matter is getting adjourned for the second. They are only supposed to give us the checks where the home buyers are waiting for it. There could be a possibility of early hearing.
When whichever date you want, take.
Please. Serial number 47, I filed for recalling so that I could comply with the office objections. I just have to annex the typed copy, your lordships.
Serial number 59 is a medical education matter. NEET exams are over yesterday. Medical education matter. One seat has to be reserved by virtue of the judgment of the Honorable Supreme Court. Before vacation, it had come. I had mentioned to the Honorable Court, today it is fixed. Medical education matter, some date in the next week.
Take date. whatever.
Please.
39,
52.
Yeah, early date.
Date is now handed over to courts.
Court officer? Court officer, serial number 58. Court officer?
Court officer. Court officer. Okay.
ಸಾಹೇಬ್ರಿದಾರಲ್ಲ
जीतेंगे
For pronouncement of judgment in writ appeal 231 of 2024, connected with 230 of 2024.
So this takes care of writ appeal number 230 of 24 and 231 of 24. In light of the above discussion and in aforesaid view, no error could be booked in the judgment and order of law on a single judge. The same is upheld. Both the appeals are dismissed. So thank you, brother. Thank you.
नमस्ते जी